not be derogated from. Then your lordship sees 5, which is the extension of jurisdiction, just for the sake of completion. Then please straight away come to section 11, which is at page 110. Not 11 is titled Appointment of Arbitrators. This is based on Article 11 of the model law. And what the other side relies on, my lord, is 2. Subject to subsection 6, the parties are free to agree on a procedure for appointing arbitrator. Lordships have seen that. Then 6 is where the appointment is made. When an application is filed, parties to request the Supreme Court or the High Court. 6A, your lordships have seen in a different context, my lords, earlier in the NN Global saga. But please come to 8, because we rely, my lord, on 8. 8 is post-amendment, and therefore the Law Commission report becomes relevant insofar as 8 is concerned. The Supreme Court, or as the case may be the High Court, or the person or institution designated by such court before appointing an arbitrator shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1, 12(1) and have due regard to. So, my lord, this is something which is deviant from the procedure. And have due regard to qualifications required for the arbitrator by agreement of the parties, and B, the contents of the disclosure and other considerations as are likely to secure the appointment of an independent and impartial arbitrator. So, my lord, 11.8, and it has been judicially also held by this honorable court, by your lordships, that you are required, I would not even say, my lord, you are it's a discretion. You are required to deviate from the procedure to ensure that the tribunal that you appoint under 11, the court, is an independent and impartial tribunal. So, my lord, 11.8 is crucial for our purposes. I will show some the Law Commission report on that, and, my lord, some commentary on that. This, in my view, is something which Core has completely missed. 11.8 has not been noticed. Then, my lords, may go to section 12, which is at page 113. 112. Well, this will be elaborately argued by, my lord, various others here. I'm just touching on it. 12 is grounds for challenge. This has been amended drastically after the 2015 amendment in view of the Law Commission report. 12 has been substituted. My lord, various disclosures are to be made. And then important is 12.5 at page 113. This is de jure ineligibility. Notwithstanding any prior agreement to the contrary, any person whose relationship with parties or counsel or the subject matter of the dispute falls under any of the categories specified in 7th schedule shall be ineligible to be appointed as an arbitrator, provided parties may, subsequent to disputes having been arisen between them, waive the applicability by express agreement in writing. So, 12.5 talks of about 7th schedule ineligibility. The lordships have interpreted this in a number of judgments with this proviso. So, 12 has to be read with 11, because 11 now 8 requires a disclosure by a prospective arbitrator, which wasn't there earlier. So now when the matter comes, say, before your lordships under section 11 or before the High Court under section 11, if such a panel is to be operated, they will have to make a disclosure of whatever relationship they have, and independent of that disclosure, your lordships will ensure that there is an impartial and independent tribunal. So the moment that burden is cast upon the on the court, my lord, then there is a problem with these panels, which are unilateral. There is no problem, my lord, with a panel of an institution or an independent panel. So, my lord, 12.5, 13 is the challenge procedure. I'm not troubling your lordships. 14 is failure or impossibility to act. That is de jure. Your lordships are familiar with that. Then please now come to one other portion. In fact, I was very happy that the learned SG had highlighted that portion in his written submissions, because we were also intending to rely on it. Please come now to page 115. This is something which has been hinted at in some of the judgments, but not spelt out. Well, chapter 5 is sections 18 to 27. Two sections here are crucial to my submission, my lord. First is 18. Conduct of arbitral proceeding 18. Equal treatment of parties. The parties shall be treated with equality. This is one part. And each party shall be given full opportunity to present this case. Noted in the learned SG submissions as the Magna Carta of arbitration. And, my lord, which we will show that this equal treatment principle applies even at the stage of the composition of the tribunal. And that will make good, my lord. So,
of course, the chapter heading says conduct of arbitral proceeding.
But the commentary, my lord, and particularly section 21 has to be read with 18. 21 suggests, my lord, that the commencement of the arbitral proceedings starts when the request is given. Your lordships are familiar with 21. So the appointment of the arbitral tribunal actually comes after that.
Absolutely.
And, my lord, the idea is simple. Whatever contractually you've agreed. But once you are before a quasi-judicial body or a substitute for the court, then all rules of fair play have to be there. You should be before somebody who's independent and impartial, and you should be treated equally. So, my lord, our submission is 18 squarely applies, and we'll, my lord, show that. So this is one separate portion of the act which has really squarely not been considered. It's been hinted at in a couple of judgments, but it's not been considered. 18 and 21. And then, my lord, just to complete this, please now come to 34. 34 is at page 121. As your lordships know, there are two limbs to 34. One is party and one is, my lord, public policy. The two portions I want to show, which are of some relevance, my lord, is 34.2A2 and 34.2A5. An arbitral award may be set aside by the court only if the party making the application establishes on the basis of the record that the arbitration agreement is not valid under the law in force, law to which the parties have subjected, or failing any indication under the law for the time being in force. So, arbitration is not valid under Indian law as a ground for setting aside an award. And more, my lord, pertinently, 34.2A5. There's some very interesting commentary on 2A5, my lord. The composition of the arbitral tribunal, which is what we are, my lord, now looking at, or the arbitral procedure was not in accordance with the agreement of the parties. This is party autonomy, unless such agreement was in conflict with a provision of this part from which the parties cannot derogate. So, my lord, this is the second place in the act where the word derogate is used. So, even if you have an agreement between the parties and that agreement derogates from a mandatory provision of part 1, the award can be set aside, or failing such agreement not in accordance with this part. No, that's the other position where there is no arbitration clause. Manoj, I must mention here there is a 3-judge bench judgment which is a little problematic. I'll come back to it. So, Manoj, these are the sections which are relevant for the purposes of our limited issue of unilateral appointment of a panel. Now, Manoj, before I go to the 4 judgments, may I now just invite your lordship?
Mr. Banerjee,
Yeah.
just before we leave this statutory provisions, this chapter 5 is conduct of arbitral proceedings.
Correct.
Now, only by virtue of what is contained in section 21, you are saying that it will also relate to not just conduct of the proceedings, but also
The
commencement
composition
and composition of the
And
tribunal.
my lord, I will show your lordship some commentary on this very Article 18, which suggests that the composition is also covered by 18. The heading, no doubt, seems to suggest.
Yeah, heading is a little
Yes.
misleading.
But
Contrary to
yes,
what you
your
are trying
lordship
to
is
say.
absolutely right. But I will show, that's why I wanted to mention, my lord, I will have to establish that this provision is relevant for the composition stage. And that, my lord, we will establish by the relevant, my lord, material.
Now, which are the non-derogable provisions of the part in regard to composition?
Right. Now, my lord,
That's section 12,
my lord, I would say 11.8,
12.5.
11.8, 12, 18 for our purposes. Well, in fact, there was a very long debate in the working group. They wanted to make a list, but they didn't make ultimately they didn't make a list. They said it is to be this thing. There are two judgments of our court, one on 12.5 in Harsak and one on section.
Forget all the judgments because we are a constitution bench. You argue as a matter of first principle.
So, my lord,
Then
12.5.
we look at which judgments fall in line with what we are ultimately
Judgments,
inclined
I
to.
understand. 12.5, my lord,
You argue it as a first
is mandatory.
12.5 is mandatory.
12.5 is mandatory. 18 is mandatory.
12.5.
12.5 read with 11.8 because, my lord, 11.8 refers to 12. So 12.5 read with 11.8 and 18, according to my lord, submissions, are mandatory, and the commentary also says so. There are various other provisions which are mandatory, but it is not necessary to enumerate the
Now,
complete.
I'll pose to you a hypothetical. Any arbitrator cannot fall within the degrees of prohibited relationship, if we can use that expression, which has been spelled out in the 7th schedule. Now, what if one of the clauses, what if the arbitration agreement provides that one of the parties shall appoint? Can such a clause be made consistent with 12.5 by saying that the persons whom that party appoints should not in any way be in breach of the 7th schedule? Will that then be a provision which will be in conflict?
Mulot, 12, the answer there is, Mulot, unilateral.
Is unilateral appointment itself by itself
That is
contrary to the provisions of the Act?
Yes, Mulot, because
one is that any appointment which of an arbitrator who is in conflict with the 7th schedule is absolutely a non-derogable provision of the statute. But does the Arbitration Act itself frown upon unilateral appointment per se?
My lord, that is how your lordships have interpreted it in two judgments.
No, but forget the judgments for a moment.
Lord,
Where did we get
is
that? Where did we identify the?
Yes, my lord, I identified it, my lord.
Can trace it only to 18.
I identify it in this fashion, my lord. It flows from the amendments made pursuant to the Law Commission report, which frowned on unilateral appointments. The Law Commission, therefore, my lord, I want to show that, and I want to show the amendment, particularly 11.8.
So now that you have formulated shown us the statutory provisions, what you can do is this. You now formulate your points. You formulate your submissions. Then we will go into then we go to the 4 judgments, the Law Commission report. So you can just formulate your submissions now.
Right, my lord, my submissions are, my lord, I am only on panel because there is no challenge subject to correction.
You are only on
panel, my lord, unilateral panel. My lord, because I know your lordship has asked me the question whether unilateral appointments are, my lord, are eschewed generally or not. But
suppose the railways, for instance, says that, look, we will have a panel of people who are not connected with us at all. We have a panel.
Absolutely. My lord, I have to answer that.
We have a panel of retired judges.
We have a panel of impeccable, my lord, integrity, etc.
Is that permissible under the statute?
Right. My lord, according to us, no. And I will formulate 4 or 5, my lord, under 4 or 5 heads.
All right. Now, why don't you just take the next 3 or 4 minutes and formulate your submissions? You can You can, we've asked you a question right at the beginning, but it will help us to formulate your points. You can, if you want to read your written submission, we can read your written
That
submission.
will come to them. There are four grounds on which, different jurisprudential grounds on which,
All right, just formulate that.
there are four jurisprudence. My lord, one is that a panel unilaterally appointed by one party.
One thing.
Control, you want to mention control? My lord, the better word would be unilaterally controlled by one party. A panel unilaterally controlled by one party, my lord, would fall foul of section 11(8) read with section 12, in that it would not be independent and impartial. This is the first, my lord, first ground. 11(8) read with 12.
In that it will not be
An independent and impartial tribunal. It may be impartial, but it is not independent. It will not be an independent and impartial tribunal, which is a non-derogable, my lord, facet of arbitration jurisprudence. It has to be independent and impartial. Otherwise, the entire, my lord, edifice collapses.
But independence, is it a quality in the arbitrator or is it in the process of appointment?
It's in the process, my lord. I will show, my lord, there's a very nice paragraph. I will show, my lord. Independence is qua, my lord, the clause, my lord. We are not on individual arbitrator.
The argument could be really that you must avoid an appearance of bias, not just actual bias.
Right, my lord. The actual bias we are not alleging.
So far as to say that, well, I'm aggrieved because this particular panel which they have appointed is suffering from lack of independence. But the fact that one party controls it
is, I will show, my lord,
the principle that there must be it must generate confidence in the arbitrating parties. It must generate a sense of credibility.
I have four heads under which your
not just actual bias, it's an appearance of bias which must be avoided.
One is the bias argument. My lord, I am on the
independence argument.
Independence argument, because if your lordship sees 11(8), my lord, one is disclosure, bias, etc., and just show 11(8) again.
It will not be an independent panel.
Yes. So, my lord, this is an important question, my lord, because let me not put it very bluntly.
And one more sentence you can add there in your first proposition, that a panel which is exclusively controlled by one party, according to you, suffers from a lack of independence.
Right. This is, my lord, proposition 1.
For that, you will have to drawings from 18.
18 is separate.
Able to draw
18 is one more. This is, my lord, 11 read with
18 is limited in its scope.
18, my lord, 18 is, my lord, secondly, any clause which, my lord, does not, your lordship has, that exactly the question Justice Roy put to me, limited in its scope, my lord, I will satisfy your lordship on that separately. The second limb, my lord, it's a second ground on which I put. There are various, my lord, four grounds we have formulated.
Independence may be also looked at from the perception, because now we're not talking about a lack of independence to challenge an award.
Correct.
All right. Just as when you challenge, say, a judgment of a court on the ground that the judge lacked independence.
Correct.
The threshold is very high. That the judge had some interest in the subject matter or was connected to the parties to the dispute, so on and so forth. But independence at the stage of composition is a matter of perception. Because you are entering into a judicial proceeding, which is an arbitration is a substitute for a judicial proceeding. So when parties are entering upon arbitration, it is their perception of an independent adjudicator or lack of independence, which is crucial. Because you must create conditions which foster a sense of confidence in the process.
In fact, 3 phrases, my lord, have been...
Whether in fact that person was eventually independent or otherwise begs the question.
In these cases, my lord, all the 4 cases before your lordships are railways and railways connected cases. From time immemorial, they have something called clause 64. The problem here is, my lord...
So independence at the stage of composition is not an objective test of whether someone would or would not be biased. But the perception of a party who is accepting,
correct. I am obliged.
That perception must be that of an independent adjudicator.
Absolutely. My lord, in fact, three phrases are used in judgments: major objective, paramount consideration, and important consideration. A paramount consideration is independence. Just show me. Of confidence so far as our arbitrators are concerned. If you have such a panel, the result both ways is bad. If the panel appointed by one set of one party decides in the favor of that party, the other party always has that lingering doubt that Mr. Banerjee was appointed on the railways panel, so therefore he has a predisposition.
No, but the other, look at it from the side of the public sector.
The other problem.
Look at it from the, we must look at both sides.
No difficulty,
A
Manoj.
public sector organization always has this fear that, look, I mean, look at what's happening in the arbitration.
Correct,
It will be taken
now
for around, we'll have a 20,000 crore award.
Now you see this one-sided panel story. Now the one-sided panel, Mr. Banerjee now gives an award in favor of the contractor. Now, immediately, my lord, all sorts of issues arise there, may be genuine. So, my lord, the solution is not a one-sided panel. The solution is staring in the face, my lord. The solution is an independent panel by an independent institution. That is why we are crying hoarse that we should have institutional arbitration. The problem is not the individuals in the panel. The problem is who makes the panel. The moment today, my lord, both ways you lose.
Not saying that we need independence and full stop. The problem is arising, what is the criteria? What are those principles on the basis of which we are going to determine that there is lacking of independence here? Everybody agrees that they have to be independent.
The very fact, let me put it this way, Manoj. The very fact that one party is appointing somebody, my lord, is unfortunately enough, because, my lord, what was arbitration? Arbitration was where both parties had confidence in the individual. Here you are basically putting up a list and asking one. So there will never be any confidence in that list of the other party. One of the articles said unloved and unappreciated panel. One party puts up a panel. My lord, please keep the distinction between, my lord, the process of appointment and the eligibility of individual arbitrators.
So your first point I have formulated, a panel unilaterally controlled by one party would fall foul of section 11(8) read with section 12. In that it will not be an independent panel. A panel appointed by one party will lack a degree of independence.
Correct.
That's the first point. What's the second
Even
point?
if impartial, my lord, I assume for a moment, my lord, impartiality, etc., will come in, my lord, when you have employees, retired employees. I am going one step further, assuming you have absolutely, my lord, respectable people.
What's the second proposition?
What's the next proposition?
My lord, the next is it will also fall foul of,
What will fall foul? Unilateral appointment.
yes, also fall foul of, my lord, the principle, the Magna Carta of equality between the parties. I'll satisfy your lordship.
Unilateral composition of a panel.
Yes.
It also violates 18.
80.
It violates 18.
Violates 80.
Level playing field.
Sorry, my lord.
Level playing field.
Level playing field. This is the logic, my lord, used by Justice Sikri also, level playing field. Justice Bhanumati also, same level playing field. So the sentence is there, the section is not there.
So you want to extend 18 to even appointment process?
My lord, I will show that there is material to show that it actually covers the appointment, the composition process. I will, it's not just my submission, my lord.
What's the next point?
Third point, my lord, which is, I would say 3A and 3B, my lord, is that such a clause, particularly in respect of PSUs, my lord, falls foul of 14 and unconscionability. A large number of judgments, my lord, some of which the learned SG has also referred to, is this sort of arrangement is unconscionable, contrary to section 23. There are a series of 10 US judgments. I will show only one. There's a chart the SG has given. I'll show one. So, these are broadly the reasons for which this sort of panel should not, my lord, be permitted to subsist. The band-aid solution is, and this is what the high courts are struggling with, a panel as in core may be bad because it's very restrictive, but if it is sufficiently broad-based, it may be okay. So, my lord, this is
not
how
going to
the court,
degrees at all. You are just saying that, look, exit out.
the problem is today there are a series of judgments. Every time an 11 is filed, how many people are there? What are their qualification? Is 31 enough? Is 37 enough? What about 100? There is a Sarot panel. So this is a solution, which came out of Voestalpine, and it's, in my respectful submission, my lord, it's a band-aid solution. Because even if there are 100 people, and even if they are, my lord, impeccable, there is always, my lord, I'm appointed to a panel by the railways. In the back of my mind, if I possibly decide in their favor, maybe I'll get another appointment. That may be a perception. I may be, in my mind, absolutely independent. We've had instances where people have been removed from panels.
Independent and impartiality is not in the degree.
It's not in the degree.
It is in its absoluteness.
And what you facially see, my lord. What do you see?
But is that your 3A point?
That's
What's your 3A? 3A is that.
3A, 3B, my lord, are unconscionability and Article 14. My lord, legally, I am putting.
To take what Brother Narsimha just said, that independence and impartiality
is not a matter of degree, my lord.
but of.
Well, no, it has to be facially judged.
But is an absolute. It is absolute.
It is absolute.
So therefore, even if theoretically the party which has unilateral control proceeds to prepare a panel which is otherwise absolutely, objectively independent.
Perfect.
The objection is not on whether those people who are put in the panel are
eligible,
otherwise
ineligible,
eligible or ineligible.
It's
But
the
the
source.
appearance of the process.
It's the process, it's the source. If you cannot, it also flows from the other principle. If you cannot unilaterally appoint somebody, can you then have a panel of 100 from which I have to choose? The source is the problem. The problem is not the panel. The problem is the process. The problem is the person who presents you with the fait accompli.
All right. We've seen now all the provisions.
Right. All the provisions.
Your submissions are complete now. Anything else in
Manoj, now I'll show the material, Manoj. The material.
now.
The material. Manoj, your lordships may first see the law commission.
Let's
Your
see.
lordships have not seen those 4 judgments. Am I required to show the?
Let's first see quickly the law commission, the material, and then we'll quickly look at the judgments.
Right.
The judgments at the end, because
Judgments at the end. Right. Your lordships don't want to be colored by
exactly
2 or 3
they are, of course, of persuasive authority. They have judgments of our
Correct.
courts. We'll
Correct.
look at them at the end.
Manoj may first see the law commission report because some paragraphs of that are very, very important.
Is that in the documents?
Where is my just a minute? Just give me a second. Manoj, this is serial volume 4, page 2722. Serial number, tab number
8.
Compilation of documents, right?
compilation.
Volume 4A or 4?
4.
Page
2722 is tab number 8, but the only relevant paragraphs are from page 2756.
You must compliment the juniors who have prepared the compilation, are very well prepared.
Yeah.
Otherwise, I tell you what we have is compilation of judgments by Mr.
Yeah.
Gaurav Banji, compilation of judgments by Mr. Neeraj Kaul, compilation by Mr. Shashankar or whoever. So it's such a headache because when you start dictating a judgment, you have like 10 compilations. The idea is to have one compilation, which everybody puts their cases together, you know.
The system is working well.
The system is working well, actually. Yeah. I think it's, thanks.
Now, we come to page
Over a period of time.
2756. 7 paragraphs are relevant. I'm just reading a few of those.
46 report.
246 report, Justice A.P. Shah's report. It starts at para 53. It is universally accepted that any quasi-judicial process, including the arbitration process, must be in accordance with the principles of natural justice in the context of arbitration, neutrality of arbitrators viz. Their independence, impartiality is critical to the entire process. Then, my lord, 54, the test for the 12.3 has been set out. 55, my lord, is what was the previous position. Then, my lord, 56. The limits of this provision has been tested in the Indian Supreme Court in the context of contracts with state entities naming particular persons' designations associated with that entity as a potential arbitrator. Appears to be settled by a series of decisions in the Supreme Court. Then, my lord, your lordship leaves all the decisions that arbitration agreements and government contracts will provide for arbitration by a serving employee of the department valid and enforceable. While the Supreme Court in IOC Raja Transport carved out a minor exception when the arbitrator was the controlling or dealing authority, and this exception was used by the Supreme Court in so-and-so to appoint an independent arbitrator under Section 11, this is not enough. The balance between procedural fairness and binding nature of these contracts appears to have tilted in favor of the latter by the Supreme Court, and the Commission believes that the present position of law is far from satisfactory, since the principles of impartiality and independence cannot be discarded at any stage of the proceeding, specifically at the stage of constitution of the arbitral tribunal, incongruous to say that party autonomy can be exercised in complete disregard of these principles, even as the same has been agreed to prior to the disputes having arisen between the parties. There are certain minimum levels of independence and impartiality that would be required of the arbitral process, regardless of the parties' apparent agreement. Sensible law cannot, for instance, permit appointment of an arbitrator who is himself a party to the dispute or is employed by or similarly dependent on one party, even if that is what the parties agreed. So, my lord, there is a This is the logic of the Law Commission. Commission hastens to add, Mr. P.K. Malhotra, ex officio member of the Law Commission, suggested having exception for the state, allow state parties to appoint employee arbitrators. Commission is of the opinion on this issue cannot be any distinction between state and non-state. Concept of party autonomy cannot be stretched to a point where it negates the very basis of having impartial and independent adjudicators for resolution disputes. In fact, when the party appointing adjudicator state, duty to appoint impartial and independent, much more onerous, right to natural justice cannot be said to have been waived only on the basis of prior agreement between the parties, time of the contract before arising. Large-scale amendments have been suggested. Fundamental issue of neutrality, Commission believes is critical. In particular, amendments 11, 12, and 14. Your Lordships have seen those amendments. Then, my Lord, 59. Commission has proposed requirement of having specific disclosure to arbitrator, state as possible appointment regarding existence of any relation of interest of any kind, likely to give rise to justifiable doubts. Then they talk about the fourth schedule, sorry, the IBA guidelines. I'm not reading all that. Please come to 60. So the 59 distinguishes between de jure eligibility, ineligibility, and the 7th schedule, and then 60 is the exception. And Manoj, this exception now, according to railways, they have a clause where there's a format where you sign on a 12-5 agreement. So that is now presented to you initially before you, for you to waive. And many, my Lord, contractors then waive it. But that was not the purpose of this exemption. The Commission, however, feels its real and genuine party autonomy must be respected. Certain situations, parties should be allowed to waive even the categories of eligibility set out Provost Fisher. This could be in situations of family arbitrators or other arbitrations where a person commands the blind faith and trust of the parties. I don't think anybody can raise this to this level. Despite the existence of objective justifiable doubts, deal with such situation, Commission proposed a proviso to 12.5. Parties may, subsequent to disputes having been arisen, waive the applicability. The general rule has to be followed. If the High Court is approached in connection with an appointment of arbitrator, Commission has proposed seeking disclosure, so on, and which context or the designation is to have due regard of the contents of such disclosure. So this is the relevant portion of the Law Commission report. Now, would your Lordships look at the four judgments now, or should I put the material? Whichever way, my Lord.
Let's see the material. I said we are done with that.
So, my Lord, I'm skipping those 4 judgments, my Lord. I just want to mention, my Lord, that we rely on certain paragraphs in your Lordship's judgment in Lombardy. And in particular, my Lord, we rely...
Why don't you cite those judgments then, and then we look at the material at the end.
Right, my Lord. There are 4 judgments which are in play, and Lombardy, my Lord, is the basis on which we have made our submissions. My Lord, the 4 judgments in play are, the first, I'm not going in chronological sequence, my Lord. There is TRF and Perkins, which are in respect of appointment of sole arbitrator. That's one category. Then there are 2 judgments. There is Core and a judgment called Voestalpine, which is the DMRC judgment, which is in the context of panel. So, my Lord, I will first show, I will not even, in the interest of time, my Lord, I will not show TRF. I will show Perkins, which then also reflects TRF. So, I will show Perkins, and then, my Lord, show Core, and then Voestalpine, which is some sort of, my Lord, halfway house. I want to show these 3 in that order, and then, my Lord, I'll make myself. First, if your Lordship sees Perkins. Perkins Eastman versus HSCC, 2019-17 SCR 275, tab 51 of volume 3, page 1254. This is the judgment your Lordships have been consistently following. I believe, my Lord, also in Glock, etc. This court has followed this.
That volume?
Volume 3, page 1254. Tab 51. The judgment dated 26/11/19, following TRF. This was, my Lord, an 11.6. In fact, all the 4 matters before your Lordships are at the 11.6 stage. Now, in this judgment, one issue was whether it was an international commercial arbitration. That issue does not arise here. Please come straight away to paragraph 11, where the second issue arises. Before that, if your lordship wants to, this is para 11, where the second issue arises, page 1268. And the clause is basically the at 1269 D. The lordship sees that unless otherwise any dispute between parties in accordance with the agreement shall be referred to sole arbitration of MD or of buyer or his nominee. Venue shall be in Delhi. So this was the clause. Paragraph 14, my lord, TRF and ergo is quoted. 15 to 20 is relevant for our purposes, my lord. 15 starts at the bottom of page 1272. It was thus held that the MD became ineligible by operation of law to act as an arbitrator. He could not nominate another person to act as arbitrator. Once the identity of MD was lost, power to nominate somebody else, an arbitrator also lost. Relevant clause in case had nominated the managing director himself to be the arbitrator, also empowered the MD to nominate another person to act as arbitrator. MD thus had two capacities. First as arbitrator, second as an appointing authority. Present case we are considered with only one capacity. Then we thus have two categories of cases. First, similar to one dealt with TRF, managing director himself is named as an arbitrator, additional power to appoint any other person. You know, this the finding. I'll just read this one. Appoint any other person of his choice or discretion as arbitrator. If in the first category of cases, MD was found incompetent because of the interest he could be said to have having in the outcome or result of the dispute, element of invalidity directly relatable arise from the interest he would be having in outcome of the decision. That be the test. Similar invalidity would also arise and spring even in the second category. Interest he has in the outcome likely to be taken the basis possibility bias always be present irrespective whether matter. We are conscious that if such deduction is drawn from decision so and so, all cases having clauses similar to that with which we are presently concerned, party to the agreement would be disentitled to make any appointment of arbitrator on its own, always be available to argue party official having disentitled. But in our view, that has to be the logical deduction from TRF Limited. Para 50 of the decision shows that this court was concerned with the issue whether the MD, after becoming ineligible by operation of law, still eligible to nominate an arbitrator. Ineligibility referred therein was a result of operation law. Person having an interest in a dispute, outcome of decision therein must not only be ineligible to act as an arbitrator, not be eligible to appoint anyone else as an arbitrator. Such person cannot and should not have any role in charting out any course to the dispute resolution by having the power to appoint an arbitrator. Will not we rely on this portion. The next sentence in the paragraph further shows that in cases where both parties could nominate their respective arbitrators of their choice, this is the critical portion, of their choice, were found to be completely different situation. The reason is clear that whatever advantage a party may derive by nominating an arbitrator of its choice would get counterbalanced by equal power with the other party. This is the section, this language is essentially, 18 language, because this is arbitrator. This is a classic case, my lord. I appoint one arbitrator, the other side appoint another. But in a case where only one party has a right to appoint a sole arbitrator, its choice, so my lord, your lordship will apply this logic to the panel, will always have an element of exclusivity in determining or charting the course for dispute resolution. Naturally, the person who has an interest in the outcome of the decision must not have the power to appoint a sole arbitrator. That has been taken as the essence of the amendments brought in TRF. Then, my lord, 17. So this is the critical paragraph is 16. 17, my lord, Raja Transport is mentioned. This is a pre-amendment case. The relevant portion of 17, your lordships, will come to page 1276.
So, Mr. Banerjee, the proposition is that your choice to make or nominate an arbitrator cannot be limited to the offerings laid out by one party.
That's our case.
So
that's our
in a situation like this, it is not a choice that is being exercised, but you are confined to the offerings that is given by the other side.
Correct, correct. It's a poisoned well. It's a limited, my lord, it is.
But it's again a matter of perception. Somebody from amongst the panel can also render an award against the, the authority which has made the...
In fact, that is exactly what happened. The panel in the DMRC case was of 3 engineers nominated from the railway panel. The same clause, which your lordships dealt in DMEPL, is the same clause where 3 are nominated. 1, I pick from theirs. 2nd, they pick from theirs. 3rd, they pick from theirs. 3 members may go that way. My lord, there are all sorts of problems with that also. Therefore, my lord, this limited choice is where I should have my liberty, they should have their liberty. Alternatively, neither should have liberty. We go to somebody independent, and that either it is an institution which is independent and appoints in which you believe, which has credibility, or the court who appoints somebody independent. Then I don't have a problem. They don't have a problem. Neither of us have a problem. Even if the award goes against me, the tribunal, my lord, it's a matter of faith. Every case we come across, you scratch at the surface. The main problem is...
Banerjee, the only point is, just reflect on it. I don't know whether that consideration is at all relevant. Is there a risk of killing the golden goose in the sense that what do government say? We are not going to go to arbitration at all.
My lord, they have themselves set up institutions. It's not that there are no institutions available to them. My lord, they have themselves set up institutions. Surely somebody has to be believed. My lord, that there has to be some, either you believe the courts or you believe your own institution. It can't be. I follow, my lord. That is exactly.
The judgment is over.
Yeah, my lord, just one last paragraph. This is what just above 18. My lord, 18 is, this was the...
Judgment.
Yes. Well, no, this judgment also is very helpful because it quotes some portions of Voestalpine. So I'll just place it from here.
Yes.
Monod, please come to para 18, Monod. I just want to read 18 for 1 second, Monod. Sure. Sub-paragraph, this is in fact, even the old law. 8 of the aforesaid paragraph 48 lays down, Monod, please just read that. 8, just above. If circumstances exist giving rise to justifiable doubts as to independence, impartiality of the person nominated, or if other circumstances warrant appointment of an independent arbitrator, by ignoring the procedure prescribed, Chief Justice may ignore the designated arbitrator appointment. So, my lord, if circumstances warrant appointment of an independent arbitrator, even prior to the amendment, and that is what your lordships have said in para 66 of Lombardy, you for the purpose of appointing an independent arbitrator, you have the power, indeed the duty under 11A to do it. And that is what was missed in core. If somebody has approached a court can't say, this is the procedure, I am a post office, this is exactly what I have to do, you please do this. So, my lord, 11, this paragraph is relevant. Then, my lord, various quotations are there. Then 19 is Voestalpine. These are very, my lord, hard-hitting paragraphs, 20, 21, 22, and 30, which has been set out in Voestalpine. So, the DMRC case. Independence and impartiality are hallmarks of any arbitration proceedings. Rule against bias, one of the fundamental principles of natural justice. Applied to all judicial, non-judicial. For this relation, notwithstanding fact relationship is contractual. Source of arbitrator is deduced from the agreement. Notwithstanding same, non-independence and non-impartiality, such arbitrator would, though commercially, would render him ineligible. Genesis behind the rationale, even when the arbitrator is appointed terms of contract by the parties of contract, he is independent of the parties. Functions and duties require him to rise above partisan interests of the parties. So this is, my lord, one portion where Jivraj and Hashwani is quoted. And similarly, my lord, the French court is quoted. Then 22. Independence and impartiality, two different concepts. Arbitrator may be independent, yet lack impartiality. Impartiality is more subjective. Independence, more objective concept, straightforwardly ascertained by the parties at the outset in the light of the circumstances. Partiality will more likely surface during the arbitration proceeding. Then, 30. Time has come to send positive signals to the international business community in order to create a healthy arbitration. Furthermore, as enlightened by the Law Commission, duty becomes more onerous in government contracts. One of the parties is a public sector undertaking itself. In the instant case also, choice is given by DMRC, limited to choose an arbitrator from panel, becomes imperative. This is the broad-based panel argument. I'll come to that later. In the light of report of so-and-so, imperative of creating healthy arbitration, then that's all that is relevant in this judgment. The rest is on maintainability, etc. So this is...
Mr. Banerjee, can we just take a 2 or 3 minute break? I just suffered from a lower back ache last week.
Please.
For 2 or 3 minutes, I just want to take a little break and come back. That's all. Just walk a little bit in the passage and come back. Just 2 or 3 minutes. Yes.
No, I've had a little rethink. I'll show the core judgment and the Voestalpine judgment later. Let me first show the material, because those judgments, in any case, your lordships will have to consider. But let me, my lord, since I'm showing the material, and let me show the material as to what is on record. One of the first proposition is that party autonomy is not unfettered. There are some mandatory provisions. And, my lord, for which purpose your lordships are permitted to, or permitted, well, I wouldn't say required, to look at the preparatory material, which is the basis of the article, which is then the basis of the section. Well, not in fact, very interestingly, when the UN General Assembly recommended the model law to us, to all the countries, it asked the Secretariat to send the travaux préparatoires along with it. That resolution, my lord, is one page, it's on record. Lordships may just see, which is why, my lord, we are relying on the travaux. That is volume 3, serial number 162, page 5015. It makes very interesting reading, my lord. This is the General Assembly resolution by which model law was recommended. 5015. Sorry, volume 4.
Volume 4.
4.
Model law on international commercial arbitration at UNCITRAL. Is that
volume 3, madam.
Volume 3.
Volume 3.
We've got it. Volume 3, 5015.
No, this is the General Assembly resolution.
The General Assembly resolution.
I'm not going to read the whole thing, but please see, after being recognizing, convinced, noting, convinced, requests the Secretary General to transmit the text of the model law together with the travaux and and recommends that well, this is the resolution
Column, left column.
What is the page again, Mr. Ben?
Pages 5015.
Left column?
Under the General Assembly.
Yes, General Assembly, 40th session, 40/72, model.
The General to transmit the text of the model law
along with the travaux, and recommends that all states give due consideration. So they actually, my lord, not only sent the text, but they also sent the travaux. That's the only reason I'm. But it gives you the basis, my lord, as why it is to be referred to.
Yes.
So, my lord, the first proposition is that there are certain rights which are not waivable. And I had shown your lordship article, section 4 and section 34, which uses the word derogate. And the commentary on that, my lord, is at volume 4. I'm only going to show 2 or 3 pages, my lord, not more, just to fit it in. Volume 4, serial 145, page 10149 at 10150. This is a 10150 is, my lord, 10149 is the cover of my lord.
Volume 4 is it?
Where's the book? My lord, what has happened is the material is spread over large portions of the website. There is a textbook, my lord, which is this Holzman and Neuhaus, which actually chapter wise analyzes each article. My lord, 10150 is the same as section 4. Please see the third paragraph.
Okay.
Third paragraph, second sentence, Secretariat's commentary on Article 4 makes it clear that in case of requirement of the arbitration agreement, that stipulation must be valid and in particular not in conflict with the.
We are 10150.
10150, not commentary.
Correct.
Please see the item 1, non-compliance with arbitration agreement or non-mandatory provision of what?
Compliance with arbitration. Yes.
Procedural default at issue must be a breach of stipulation in the arbitration agreement or a non-mandatory requirement. Secretariat's commentary on Article 4 makes it clear that in case of a requirement of the arbitration agreement, stipulation must be valid and in particular not in conflict with the mandatory provision. And the footnote gives the Secretariat, and that's also on record. So this shows, my lord, that there is a mandatory provision. Then, my lord, please come to 10151. bottom of the page, second sentence,
015?
next page, next page, 101511.
Yes.
Last bottom, Malone. A waiver under Article 4, however, applies only to the non-mandatory provisions of law, that is, those provisions upon which the parties may agree to the contrary. This qualification, not part of the initial draft of provisions, specifically included to soften its effect. Proposed at one point to provide a list in the law of such mandatory provisions, working group decided not to include such a list because it viewed it unnecessary subject to certain drafting difficulties. Nevertheless, a number of provisions clearly indicate their non-mandatory character, either by providing explicit freedom or providing a rule of procedure but stipulating parties may agree otherwise. Examples of provisions appear to be mandatory and therefore cannot be waived under Article 4 are the following. Requirement: the arbitration agreement is in writing. I rely on the next one, the requirement that the parties be treated with equality, each party be given full opportunity to presenting. So Article 18 is mandatory, my lord. There's a judgment of our court in Vedanta, which also says that it is mandatory. It is, my lord, 18 cannot be derogated from. That's the only reason, my lord, I'm showing this. Then, my lord, this is the commentary on Article 4. Your lordship may now see the commentary on Article 34. That's the other place where the word derogate is used. The commentary on Article 34 is at page 10054, serial number 144, little behind. 10054. This is tab 144, my lord. That's the book, Manoj. And just one paragraph I'll show at 10061. This is a little important because, Manoj, there is a judgment which seems to suggest a little differently, but I'll just read it. The second significant change was made to subparagraph 2A4 of Article 34. Corresponding clause of the New York Convention, Article 51D reads, the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties, failing such agreement, not in accordance with the law of the country where it was made. The final text of the model law includes a new phrase following the first comma, unless such agreement was in conflict with the provision of this law from which the parties cannot derogate. History of this new phrase becomes footnote. Please come to the next page. I'm not reading may I just read this one? Because it is of some relevance on mandatoriness. The history of this new phrase begins in a footnote to the Secretariat's initial draft, what became Article 36, incorporated by reference to early drafts of 34. That footnote noted that the view then prevailing amongst commentators was the language of the New York Convention gave absolute priority to the agreement of the parties, irrespective of whether such agreement is in conflict with a mandatory provision of the applicable law. Secretariat said here that this rule could not possibly apply to the enforcement of domestic awards, kinds of awards which Article 34 is concerned. Presumably, domestic courts would be, by definition, be bound to apply the mandatory provision of domestic law. Working group agreed, and Manoj, I skipped that paragraph, then last paragraph. During the Commission's consideration of the working group's final draft, which was the same as the final text, a potential ambiguity was noted by several delegations. They said that the provision might still be interpreted not to allow an award to be set aside where the procedure set forth in the arbitration agreement had been followed, but where that procedure conflicted with the mandatory provisions of law. While no change was made in the text of the law, the Commission report recorded the understanding that where the agreement was in conflict with the mandatory provisions of the law, provisions will prevail. So, my lord, and that's the same section which your lordships have seen this morning, 34 2A5. Composition of the arbitral tribunal, arbitral procedure was not in accordance with the agreement of parties unless such agreement was in conflict with the provision of this part. So, my lord, 34 2A5 specifically addresses a situation where the composition of the tribunal may be in agreement, in our case, may be in accordance with what the parties say, but if it is contrary to a mandatory provision of the law, it should be set aside. And that's, my lord, what the commentary says.
Yes, sir. Deals with a situation where the composition.
That was the intention.
Board with.
Well, there is some ambiguity in the language of 34(2)(a)(5), and it was brought to the notice of the commission. The commission says that obviously mandatory, if there is any mandatory provision, even
That will
if
prevail.
right, there is a directly opposite judgment to this. This was not cited before a 3-judge bench. There is a judgment of your lordships which says exactly the opposite, and it is my duty to bring it to your lordships' notice. Where the argument which is accepted, which is rejected, is mandatory overrules contract. Argument is, even if it is contrary to a mandatory provision, still the contract will prevail. I'll give your lordship the reference, my lord. It is Narayan Prasad Lohiya. It is at page 681. If I don't show it, my lord, it will be unfair, my lord. There is a judgment which says the opposite. I must show it.
Volume 3, page 681.
Sorry, my lord.
Volume 3.
Volume 3, page 681, my lord. Tab 22. Actually, this reasoning was probably unnecessary in this case, my lord, because it was held that it was a derogable provision. But still, this reasoning is there, my lord. 681, and the relevant portion is at 695. Lords, if your lordship sees 695 is what Mr. Venugopal argues, which is consistent with, my lord, what I showed from the working group, my lord. So Mr. Venugopal's argument, my lord, which I commend for your lordship's acceptance, is 695, my lord, page 11.
Read between placidum B and C. In other words, according to Mr. Venugopal.
Even if the composition is in accordance with the agreement, award can be set aside if it is in conflict with the provisions of Part 1. This is what he argued. Now, that is rejected by the court, and it is held at page 6, that entire paragraph is there, at 696, last sentence. Thus, so long as the composition of the arbitral procedure is in accordance with the agreement of the parties, Section 34 does not permit challenge to an award merely on the ground composition of the arbitral was in conflict with the provisions of Part 1. This also indicates that 10 is a derogable. Here,
where was this, by the way? 690?
6, last sentence of the first paragraph.
Oh, just as long as the composition of it.
The judges don't notice that, my lord, there are derogable provisions and
non-derogable.
So if it is non-derogable, you cannot, my lord, contract out of law. So, my lord, I just want to show. So, my lord, the first proposition is there are certain certain provisions of the Act which are non-derogable. Non-derogable is also a clumsy word, which are mandatory. The language uses mandatory. Two provisions which I have said are mandatory, your lordships have already noted, 11(8), 12(5), and 18. Now, the third point is, my lord, 11(8) has to be read with 18. My lord, this is one aspect which, the third point, my lord, I would say is 11(8) permits for a diversion from the agreed procedure, for which I just want to show your lordship 3 or 4 paragraphs of Lombardy. Just 3 or 4 paragraphs in Lombardy. 11(8) permits this diversion. So, my lord, if your lordship just sees Lombardy, I'm not going to read it. Your lordships, 3 of your lordships are party to it, familiar with this. Lombardy is at volume 3, page 2058. Various issues are framed, my lord. I am not going to go into it. It is that issue regarding, my lord, pre-deposit. Please first see paragraphs 81 onwards, Manoj. 81
for citing SCR.
SCR.
All the juniors have put SCR together
SCR.
because now all our judgments are in the digital form in digital SCR. Yes.
Earlier, I remember at least in the 90s,
You couldn't cite
you
anything,
could
but
not
SCR
cite
could not
anything
cite
else. It
the
was
only official report.
unless you had the judges would not even recognize an SCC or a let alone scale or something. It only
SCR couldn't keep pace. That's why others.
that's why this problem came.
Now it's
Now it's caught up.
up to date.
In fact, your lordship's direction is that they have to file only SCR copies. My lord, make straight away come to page 2105, para 82. 82, my lord. Bottom of
At page
2105. So, my lord, if I am right, the arbitration agreement has to be consistent with, my lord, 11, 12, and 18. And then, my lord, 84 is concept of party autonomy cannot be stretched. And then, my lord, 86 and 87. That's all I want to show. There are other paragraphs, but in the interest of time, my lord, I'm not showing the other paragraphs. The 86, 87 are page 994, my lord. If circumstances give rise covers composition. After all, 18 may not cover composition. It may be after the tribunal is formed, everything else. Why should it cover composition? Now, Manoj, there was some doubt on this. There are two parts to the commentary. I'll show both, and I'll show, my lord, what is the understanding generally. My lord, may first see the on 11. It's very interesting, my lord. It reads, shall we say, my lord, both ways? Shall we say, my lord, both ways? Eleven का commentary आ गया. Here's the 11th commentary. Hmm? 16. Which one? Oh, no, where is the commentary? Lordship, just give me 1 second. 10. Where's the 18? My lord, may see the 18 commentary. I'll show the 11 first in fairness, and then I'll show 18. My lord. 11 commentary, my lord, is at Lord, now I just want to show you lots of the material on Article 11 and 18, and then, my Lord, I'll continue. My Lord, on 11, so discovery of Mr. Nariman, my Lord, this is the Clout Digest.
In fact,
He was to argue that.
This was the last submission which Mr. Nariman drafted and emailed it at about 12 noon the day before he passed away, the night before he passed away.
In
he
fact,
was working on this.
A lot of the material that I'm
before he
citing
passed away.
was his independent research, my Lord, and particularly this one. So a lot of it was done by him.
From Mr. Well.
My Lord, may come to volume 4, 3807. This is part of the case law and ancestral text digest, my Lord. There is a my Lord, there is a site which collects case law and ancestral text, my Lord. I am one of the, all of us are correspondents from India, my Lord. 3807. It's a summary at paragraph 20. This is the purpose of 11. Purpose of 11 is the key purpose of 11. Paragraph 20.
Article 11 corresponds to
Section 11. In fact, it was Article 6 and 11, but 11, my Lord, corresponds to 11. Exercise of the courts or competent authorities' discretion. Securing an independent and impartial tribunal was said in one case to be the major objective that ought to be pursued by the court or competent authority intervening on the basis of 11. While in another case, it was said to be the paramount consideration. It has also been explicitly identified as an important consideration in several other cases. And footnotes, my Lord, the cases are also on record. So, my Lord, when your Lordship looks at section 11, this is one major aspect to be looked at. It is not simply procedure, appoint whoever is said on the panel, simply appoint. Major consideration is impartiality and independence. This is generally the law in respect of 11. That's why you give this power to a court or an authority. Otherwise, my Lord, anybody else could have.
21, they refer to qualifications. If qualifications are provided, the court cannot change the qualification.
Right. My Lord,
if a lawyer, if a physician has to be appointed, you cannot appoint.
I'm relying on 20.
You cannot appoint a lawyer.
I'm relying on 20, my Lord. Para 20.
Right.
20 says that this is the objective, namely independent impartial tribunal. This is the major objective. This is the paramount consideration. One says major, one says paramount. So, my Lord, when your Lordships are construing 11, otherwise, what is the joy of coming to, my Lord, a court or an authority?
Right.
You are essentially, the arbitral tribunal as a substitute. In the, it's an alternative dispute resolution, it's a substitute. So, this is, my Lord, one aspect. Now, please see commentary on 11 and commentary on 18. Commentary on 11, my Lord, is serial number 141 in volume 4 at page 10040.
It's from the same book, right?
This is the book which has all the extracts.
Tell the number again.
4040. Same one.
Tab kya hai? Tab 141. 10040. Article 11 is there, my Lord. Please come to page 10042 at the bottom. I just want to read this a little carefully, you know. Paragraph 2 of Article 11 does not state any limitations on the parties' freedom to agree on a procedure for appointing an arbitrator or arbitrators. The provision does state that the freedom is subject to the provisions of paragraph 4 and 5 of this article, similar to ours. But those paragraphs only provide for supplementary intervention by the courts in case the agreed on procedure fails to work. They do not place any express limitation on the parties. Nevertheless, in drafting paragraph 2, it was recognized that the model law as a whole implied certain restrictions on the parties' agreement regarding appointment of arbitrators. The third working group cites examples, 2 articles that give rise to such restrictions. Article 12 concerning grounds for challenge, Article 34 concerning the court's power to set aside arbitration. Thus, for example, if the procedure agreed on results in arbitral tribunal fails to meet the standards of impartiality and independence, arbitrator will be subject. Similarly, if appointment results in a party not receiving proper notice, an award may be set aside and refused recognition. These are specific restriction contain the model code, go to the effects of the procedure. These restrictions result the results of the selected appointment, not the procedure itself. Thus, the arbitration agreement does not provide for proper notice. Then, 11. Next paragraph. The working group considered at some length adding to Article 11 an explicit limitation on the parties' freedom to determine the procedure for selection of arbitrators. Provision would have stated procedure agreed upon parties would be invalid or to the extent that it gave one party predominant position, on the words of an alternative draft, manifestly unfair advantage with regard to the appointment of arbitrators. This provision was later deleted. One, problem did not arise frequently. They were not probably aware that the problem arises very frequently here, but that was their understanding. To other provisions of the law, and we rely on this. Other provisions of the law, such as 12 and 34, could be used to address the problem. Wording was regarded as too vague, could lead to controversy, dilatory practice, potentially invalidation of well-established, recognized appointment practices, while the working group concluded that such a provision had no place in the model law, and the final text accepted by the Commission confirms that decision. The working group did note that its determination should not be understood as expressing support for unfair practices. And my lord, I just want to show what exactly it said is at page 9998 of the same volume. Serial 1, I want to show the sentence actually which the working group used. Serial 137 at 9998. Well, paragraph 89, 90 and 91 is basically what is summarized in the book. The working group, 91 I'm reading, after deliberation decided to delete paragraph 2. That decision, however, should not be understood as condoning practices where one party has a clearly greater influence in the appointments without good reason. So, my lord, this was definitely something which weighed with the working group. So, my lord, this is when 11 is debated. Now your lordship goes a little further. So now the debates continue and 18 is debated. Now by the time 18 comes along, there is a little shift. Now your lordship will see the commentary on 18, which is very interesting. Just a minute. 1 minute. Have you shown this? I've shown 11. 11 is over. My lord, may come to Article 18 commentary.
It was not because they accepted such clauses, but
Correct.
they felt that the other provisions would be sufficient to deal with them.
Now, my lord, 18 commentary is very interesting. Please come to 10050. Serial 143, no, tab 143.
The previous one which you showed is part of which document?
The previous one is an extract from the
Okay.
It's tab 137, my lords, at page 982.
It is actually part of the report. That's the language of the working group report.
We are at 10050.
10050. Now, my lord, I'll just read. This is makes very interesting reading. Article 18 establishes fundamental principles. All arbitrations must be treated with equality. My lord, then it mentions Magna Carta of arbitral procedure, due process clause, etc. Then, my lord, second paragraph. In early drafts of the law, provision that now constitutes Article 18 was included as the third paragraph 19, to which, as discussed below, it's an important corollary. In order, however, to emphasize the central importance of the principle of equality and fairness, intention they apply to the entire arbitral proceedings, Commission decided they should appear in a separate article. Now, my lord, I'm not reading the next paragraph. I'm just reading maybe 10051, top one. Article 18 is thus the limitation on Article 19, which provides broad autonomy, first to the parties and second, in the absence of party agreement, to the tribunal to decide on the procedure to be followed in conducting the arbitration. Now, my lord, the point which has been raised by your lordships is addressed at 10050 5(2). The precise scope of application of Article 18 may give rise to some question. Lordships have this 10052. As noted, the Commission report states that the tenets of Article 18 are applicable to the entire arbitration proceedings. For this reason, Commission moved the provision from 19.3 into a separate article at the beginning of Chapter 5, which concerns the conduct of proceedings. In addition, I rely on this. In addition, the Secretariat stated that the provision applies even more broadly than the 9 other articles of Chapter 5. In urging the Commission to adopt the quoted interpretation, the representative of the Secretariat stated, it has always been the understanding of the working group that the fundamental principle enunciated in 19.3 article would apply to arbitral proceedings in general. It would govern all provisions of Chapter 5 and other aspects such as the composition of the tribunal not directly regulated therein. So, my lord, though one interpretation could be that it would be a very truncated interpretation. It means the tribunal is set up which is not impartial, or there is no equality between the parties, but they behave impartially. So, my lord, even the procedure of composition of the tribunal falls within that period. So once you go, till the time you don't go to a forum, you can negotiate your rights. It may be one-sided contract. Once you go to a forum, which is a substitute for a judicial forum, then, my lord, this you can't really have not a level playing field. And therefore, my lord, their understanding was that the composition is also, my lord, something which is covered. And, you know, this is one part of it. The commentaries also say this. I'll show the commentaries now, my lord, and that will also make it clear, my lord. First, if your lordship sees, these commentaries are also referred to the, my lord, just, my lord, may first see well, not Peter Binder is at page 10185, serial 147, the same volume. Happily for me, all this is reflected in the learned SG submissions also. Much of this. Section 18 is also relied on by him. We were, my lord, happy to note that he's also relying on it. I thought it might be a little difficult. Please see page 10186, my lord. This, of course, is in the context of ancestral arbitration rule. Equal treatment of the parties in the appointment process, due to the fact that it is primarily up to the parties' agreement to decide who should be the arbitrator in any given case. Also due to the fact that under 8.2, parties may determine how the appointing authority is to find a candidate for the position of arbitrator. It is important to keep in mind that the rules, as well as most national laws, Article 18 of ancestral modern law, place paramount importance on the equal treatment of parties in the arbitral process, means that no party may be given preference in the arbitrator selection process, regardless of how strong the bargaining power may be. This both in the process agreed on by the parties or in the process chosen by the appointing authority. Any violation of this principle could lead to a setting aside of the arbitral award for violation of this fundamental principle. This is one view which is given in Binder. And then, my lord, one more. I'll show there are a number of others. I'll just show one more. My lord, serial number 148, page, this is Fouchard, my lord, 10189, just 10189, my lord, at 10191. Three, limits on the primacy of the parties' agreement. 783. The primacy of the parties' agreement is not absolute. It is limited in some respects by the requirements of the proper administration of justice. 784. Certain of these limits have already been outlined and will be discussed later at greater length.
Sorry.
10191.
10191.
Limits of the primacy of the parties' agreement.
Yes.
Primacy of the parties' agreement is not absolute, limited in some respects by the requirement of the proper administration of justice. Certain of these limits have already been outlined and will be discussed later at greater length. They are the arbitrators' independent impartiality. That was my first submission. Others result from the requirement that the parties' method of appointing the arbitrators or the institutional rules chosen comply with the fundamental principles of due process. These principles include, in particular, the parties' right to fair trial and their right to equal treatment. Latter is expressed in the uncitral model law, Article 18 of which states the parties shall be treated with equality. Dutch law is also mentioned, German law is also mentioned, and those are quoted. They are much more, specific. So, these, in fact, in the recommendations by the expert committee, we have suggested similar amendments to be made to the relevant provisions. So, 18 in our respective submission is also a ground on which this clause, can be held to be contrary to the provisions of the Act in view of the observations in Lombardy, and therefore under 11.8, because there is evidently unequal treatment of the parties. It's a given deal. In fact, the entire language of Voestalpine and the entire language of even core is that you balance. So balance is only when there is equality. So this is so far as this is concerned. And one other very interesting judgment I want to put, and then I will come back to core and conclude. One aspect of this, so whether your lordships put it in the impartiality independence category or equal treatment category, the approach taken in the US is on the basis of unconscionability. Here also, my lord, we are grateful to the learned solicitor. 10 cases he has summarized in his written submissions. 10 such judgments he has summarized. I will show what I would submit. We had filed 3 or 4. Some others are there. I will show one judgment, because this issue of panel and one party controlling a panel has arisen in multiple cases in the US with multiple, this thing. I will show one, maybe if your lordships indulge, 2 cases which are very instructive. Lordship first sees serial number 140. Volume 3, page 4294. Austin Trout, my lord, 4294. Tab 140 versus the boxing organization. This was a professional boxer who wanted to avoid the clause in the WBO agreement. Tab 138. I'm so sorry, Manoj. Please come straight away to 4301. Roman 5. That brings us to Trout's last challenge, in which he takes aim at the district court's ruling by focusing solely on the arbitration selection process that the appeal regulation set forth. Trout contends correctly that the provisions grant the WBO exclusive control over the appointment of the arbitrators who will decide his case. Under its plain terms, the WBO could even appoint its own employees, including direct aides to the head of the WBO, in the arbitral panel with no input from Trout. In consequence, Trout argues that the arbitration agreement does not provide him fair opportunity to pursue either his claim under so-and-so or his claim under so-and-so to arbitrator by virtue of the method of selection would be inherently biased. Then, my lord, he cites a case which is distinguished, and your lordships come to 4302. But Trout's contention that the arbitration agreement is unreasonable and unjust just because the arbitrator selection process permits the WBO to act both as party and judge has obvious force, notwithstanding that he does not identify any direct authority in support of his contention, arbitration agreement may not be enforceable. Nor does WBO contend that Trout has forfeited or waived any agreement against enforcement. Instead, the WBO takes on argument about on its merits, and then, my lord, on this ground, there is further reasoning, and ultimately the court holds that this is a clause which is not inherently problematic and allows the appeal on that point and leaves the question of remand. These were the only two relevant paragraphs there. My lord,
this is only contention.
Sorry?
Where is the finding?
One of the I'll just show. I'll just show them. No? One of the finding is
paragraph 14 at page 4305. They don't deal with the issue actually.
Yes. Just a minute.
In determining whether the arbitration agreement should be enforced,
right?
Absent the invalid arbitrator selection mechanism, and if it should, how to select an arbitrator. However,
that second portion is
the party's intent, the federal policy favoring arbitration, and the interplay between state law and federal policy, but the parties have not fully engaged with those factors or the applicability of the savings clause. We therefore leave it to the district court to determine in the first instance whether the arbitration selection provision at issue here is severable from the...
That's the second question. On the first question, they hold that the provision is not valid, but on the issue of severability, my lord, they remove. My lord, please see the second judgment, which is very clear, my lord. McMullen, which is 139, serial number 139, 4307. Two critical paragraphs, my lord, paragraph 9 and paragraph 10. 4307 at 4314.
What
court is this?
43149. Therefore, we must decide whether, this is an extreme case, Mayor's TAP provides McMullen with an effective substitute for the judicial forum to pursue her Title VII claims. The TAP adopted by Mayor is commendably fair, except in one important aspect. It grants Mayor unilateral control over the pool of potential arbitrators. This is a case, this is not a case of retired employee, etc. This is a otherwise fair panel. Then, my lord, the first judgment relied on by McMullen is on Hooters, and that is discussed. I'm not going to read Hooters and Floss, my lord. They are all discussed here. Please come straight away to para 10.
Sixth Circuit decision to see that.
Just a minute, I'm sorry, Manoj. Please come before that to page 4315. Mayor's TAP is plainly even more even-handed than the arbitration agreement at issue in Hooters, which allowed for unfettered employer control over the potential arbitrator, contained a myriad of unilaterally biased clauses giving Hooters an advantage in every way. But the arbitration selection process provided under Mayor's is less fair than the arbitration process described as Floss is fundamentally unfair. Then, not Floss is discussed. Then at the bottom, the type of control exercised by Mayor over the potential arbitrators is analogous to the exclusive control over the entire panel exercised by the employer in Hooters and rejected by the Fourth Circuit. Furthermore, the arbitrator selection procedure used by mayor allows it to create the type of symbiotic relationship with its arbitrators that we feared would promulgate bias in floss. The risk of bias inherent in Maya's procedure is demonstrated by the fact that Maya uses the same panel of...
Because I look at it, you want to now the core because you have 5 minutes, then we'll wrap up at lunch.
Right. So, my lord, on this basis, it is held that it is not a my lord, effective substitute.
Fair enough. Now let's go to core.
Now, my lord, I'll just show your lordship's core, and then I will just 2 or 3 lines I want to say at the end. My lord, may look at core. I have not shown your lordship's voestalpine because there are number of paragraphs.
Voestalpine was in fact cited in Perkins.
In Perkins.
Para 19 of Perkins.
Right. My lord, may come to core, which is at tab 52, page 1284 at 1289. My lord. My lord, in this case, the Allahabad High Court had appointed an independent arbitrator. But the Supreme Court reversed that and stuck to clause 64. Your lordship may first see clause, the heading. One of the first heading is from paragraph 12 to 22. It starts at page 1293. Para 11 to 22, my lord, is appointment of an independent arbitrator without reference to the clauses of the GCC, whether correct. My lord, my short reply to 11 to 22 is, it does not consider voestalpine. It does not consider 11.8. It does not consider the amendment to 11.8. It does not consider the fact that there is a necessity for an impartial tribunal, though all this was there in voestalpine. So, my lord, the problem with the first finding that this honorable court says you stick to the clauses, it does not consider the developments post 2015 at all. In fact, it relies on a judgment in Parmar, which is a pre-2015 judgment. And not even, my lord, noticing that even on pre-2015, you were required to have an impartial trial. My lord, please see the clause. It's a wonderful clause, my lord. Clause 64 is at page para 15. And the relevant portion is 1297. This is what is, my lord, the clause. This is the similar clause is there in the first 4 matters. The fourth matter,
post-amendment clause, no?
Sorry, Manoj?
This is the post-amendment clause.
This is the post-amendment. Pre-amendment, I am leaving. This is the post-amendment clause.
Right.
Now, this is the clause which all railways and railway undertakings, BMRC, DMRC, etc., all the 4 cases before my lords. JSW is even worse because it has one unilateral arbitrator, but all of them have some variation of this clause. And the clause is, my lord, I am not on retired or my lord, serving. The panel has
Where is that clause?
The clause 1297, 64, 3B. In fact, my lord, it's quite interesting. First, they present you with a clause which says you please waive 12.5. They've already got a format for that. So if you're not in the business with them, then you waive 12.5 and you will not suffer the consequences. They have a set format for that. But if you don't, then you come to this. For this purpose, Railway will send a panel of at least 4 names of retired officers empaneled to work. So the panel is unilateral. Contractor will be asked to suggest at least 2 members out of the panel. GM will appoint 1 out of the 2. Balance 1 from the panel or from outside the panel. Presiding again to be appointed. So all 3 effectively, I choose 1 out of 2. 1 and the other 2 they appoint. Even the chair they appoint. So all 3 effectively are the source comes from them. If this is the panel, my lord, I ask myself, either way you will not get justice. This is completely unworkable. In fact, the learned
Has
SB
anybody
seems to-
ever done an impact assessment
this
of the number of awards? Invariably, despite all these,
They all
many of
go
the
in favor
awards
of
have
the
gone in favor of the
contractors.
contractors, hardly any in favor of.
and
You
that
have-
makes
you
it
know
not
about
much worse. According
The
to
reality is that.
that makes it much
Theoretically,
worse,
it's
my lord,
all right.
because that actually makes it much worse, my lord. If that
That this
Realities are very
cause,
different.
put the party at a serious disadvantage so far as choice of
there is, my lord, it is
arbitration
illusory.
concerned.
There is no choice. In fact, the learned SG has conceded in his note that core is wrong. My lord,
One, you have to appoint your arbitrator. You means the claimant from out of the panel suggested by the railways. Two, the other two are appointed by the
yes,
railways.
yes,
And
that's,
chairman also.
So the
by the way.
chairperson is appointed
that's
by
the clause, my lord. That's the standard clause.
Only difference between pre and post is that earlier they were gazetted officers. Now you have retired officers in the panel.
That's the only.
That's the only distinction.
So thank you, Mr.
15 minutes, 10 minutes.
Now we'll wrap up. 1
10
o'clock
minutes
means
more.
1 o'clock.
Go by the schedule.
1 o'clock means 1 o'clock. At 2 o'clock we'll hear Mr.
I will just summarize in literally in 5 minutes. I will not show any document.
No, give us a small note after that.
Just
We'll-
five
no,
minutes or not. Five
we-
minutes.
no,
5 o'clock. 5
We're,
minutes.
2 o'clock now, Mr. Paul. Thank you.
I'll start.
Yes, sir.
Check 1, 2, 3, 4. Check. 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 Mic check 1, 2, 4, 5, 6. Check.
Yes, Mr. Bala.
May I please, Your Lordships. My lords, TRF and Perkins recognize that ineligibility of an arbitrator on the grounds of independence and impartiality is a fundamental ground which goes to the root of any dispute. And such a person who is ineligible to be appointed as an arbitrator cannot be allowed to appoint a sole arbitrator to the dispute either. So both you're ineligible in your own rights and you neither have the power to appoint or nominate another arbitrator. And it then recognizes the mandate as laid down in 246th Law Commission report on the principles of natural justice, which include the rule against bias, to say that party autonomy can't prevail. Prior party autonomy or agreement between the parties can't prevail over this. Rule against bias is not only existence of neutrality, but appearance of neutrality as well. And on that issue, I'll show a very interesting article to your lordships just in a minute. And what they emphasize in both these matters is that if an overwhelming power is given to a party to appoint either a sole arbitrator or an overwhelming majority of the tribunal, you are effectively making him the appointing authority for the tribunal, who in turn would create an impression that as if he has a say in the adjudicative process and charts the course of the proceedings as they go on. That's what Perkins recognizes, that if you appoint or give someone a power to say that he can appoint the sole arbitrator or an overwhelming number of people on the arbitral tribunal and practically negates the power that the other party would have to appoint an arbitrator, you're effectively introducing a clause, and the words used are, which would lead to exclusivity in charting the course of proceedings, and which ought not to be done. Now, where core went wrong, and I'll deal with it in a minute, are the two paragraphs I'll read of Perkins vis-a-vis the paragraph in core. Perkins in para 16 of the judgment went on to say that a situation would be completely different if both parties had equal power to nominate arbitrators. Then there would be a counterbalancing that takes place. Thus there, sorry, madam. So then there would be a counterbalancing that would take place. The mistake which core commits is, it picks up out of that. This was really a tribunal, my lords. Core had a very interesting clause. It said 4 names will be sent to the other side, out of which you pick up 2. And out of those 2, that person will pick up 1. And the other 2 will also be nominated by him from with or without the panel.
Right.
Now, core picks up this line to say that, like Perkins, there is a counterbalancing in the 2, whereas the counterbalancing as understood by Perkins was a completely different counterbalancing compared to the counterbalancing which core talked about, which is no counterbalancing at all in the eyes of law. Now, my lords, in this background, please just have 2 paragraphs of a very interesting article written by Jan Paulsen, which I'd like to rely on. Volume 4, page 3663. But that's later. First 3663, my lords. My lords, with your lordship's permission, somewhere in the middle of this page is a para starting with, this has nothing to do per se with the choice between a sole arbitrator. My lord, the Chief Justice says, please. This has nothing to do per se with the choice between a sole arbitrator and a tribunal comprising 3 or more arbitrators. In either case, when each arbitrator is chosen jointly by the parties or is appointed by a neutral institution, each is invested with an equal measure of confidence and an equal claim to moral authority. Not so when there are unilateral appointment. It seems obvious that a very different impulse is at work here, introducing an adversarial element into the very deliberation of the arbitral tribunal. Disputants tend to be interested in one thing only, a favorable outcome. They exercise their right of unilateral appointment like everything else with that overriding objective in view. The result is speculation about ways and means to shape a favorable tribunal, or at least to avoid a tribunal favorable to the other side, which is logically assumed to be speculating with the same fervor and towards the same end. Forgotten is the search for the arbitrator trusted by both sides. And kindly skip one paragraph and come to the next one after that, which starts with the only solution. The only solution which will be reliable in all circumstances is that any arbitrator, no matter the size of the tribunal, should be chosen jointly or selected by a neutral body. This aspect of the process should no longer be misused as a sales argument for arbitration. Confidence enhancement is properly focused on procedural rights, the rights to be heard, the opportunity to confront the opponent's case, equality of arms, rather than risking the ineluctable contamination of the ideal that an arbitrator trusted by both sides by notions of constituency. Let's take this. And my lords, one interesting statistic that it also gives on page 3662, if your lodges were to have for a minute, on page 3662, the third paragraph from the top is an interesting statistics, which starts with, we must confront an uncomfortable fact. My lords have that?
Yes.
An uncomfortable, we must confront an uncomfortable fact, as illustrated by two studies of ICC cases in different years earlier this decade. Dissenting opinions were almost invariably more than 95% the work of the arbitrator nominated by the losing party. See, so-and-so, dissenting opinions, so-and-so, so-and-so, so-and-so. Now, my lords, one very pertinent question that your lordships put to us right in the beginning in the morning was with regard to an agreement containing a ineligible arbitrator within it, an arbitration clause. Now, 12.5 takes care of that situation. 12.5 invalidates or makes ineligible the arbitrator, not the agreement. And then read with broadband goes on to say that the moment he is ineligible in terms of section 14 and in consonance with the 246th Law Commission report, he is deemed to be de jure ineligible to conduct any proceeding. And ordinarily, broadband says that you would have gone the route of 12.1 to 12.4, read with section 13 for removal of an arbitrator. Here he is per se ineligible and is to be substituted immediately forthwith under 14. And that paragraph of broadband I'll read to your lordships, but kindly have 12.5 and 14 for a minute, my lords, the provisions. First have 12, section 12, subclause 5. Just give the page for the section. So what do you? 2, my lords.
Page 112.
112 of section 12, subclause 5. And then section 14 after. My lords have section 12. Notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator. And read this with 14. Kindly have 14. 1. The mandate of an arbitrator shall terminate, and if he shall be substituted by another arbitrator if A, he becomes de jure or de facto unable to perform his functions or for other reasons fails to act without undue delay. And then it goes on. And kindly see the interplay of the two sections as captured by this Honorable Court in Bharat Broadband. If your lordship were to have, just give me the page. Volume 3.
1181.
No, page 1200, you said? It's been changed. It's page 1181, my lords. Volume 2, para 17 on page 1200. My lords, 1200, volume 3, para 17 of Bharat Broadband. The scheme of section 12, 13 and 14 therefore is that where an arbitrator makes a disclosure in writing which is likely to give justifiable doubts as to his independence or impartiality, the appointment of such arbitrator may be challenged under section 12.1 to section 12.4 read with section 13. However, where such person becomes ineligible to be appointed as an arbitrator, there is no question of challenge to such arbitrator before such arbitrator. In such a case, that is a case which falls under section 12.5, section 14.1a of the Act gets attracted inasmuch as the arbitrator becomes, as a matter of law, that is de jure, unable to perform his functions under section 12.5, being ineligible to be appointed as an arbitrator. This being so, his mandate automatically terminates and he shall then be substituted by another arbitrator under section 14.1 itself. It is only if a controversy occurs concerning whether he has become de jure unable to perform his function as such that a party has to apply to the court to decide on the termination of the mandate unless otherwise agreed by the parties. Thus, in all section 12/5 cases, there is no challenge procedure to be availed of. If an arbitrator continues as such, being de jure unable to perform his functions, as he falls within any of the categories mentioned in 12.5, read with the 7th schedule, a party may apply to the court, which will then decide on whether his mandate has terminated. Questions which may typically arise under section 14 may be as to whether such person falls within any of the categories mentioned in the 7th schedule or whether there is a waiver as provided in the proviso to section 12.5 of the Act. As a matter of law, it is important to note that the proviso to section 12.5 must be contrasted with section 4 of the Act. Section 4 deals with cases of deemed waiver by conduct, whereas the proviso to section 12.5 deals with waiver by express agreement in writing between the parties only if made subsequent to the dispute having arisen between the parties. So that is the scheme of the Act, my lords. You are per se ineligible. And we don't have to go before you moving an application. You can be substituted under 14 with another arbitrator unless a dispute arises if you are ineligible or not. And that is why in Perkins and Trf, it was said that if this person is per se ineligible, where is the question, or to act as an arbitrator, where is the question of his nominating someone else as an arbitrator? And that is why when the reference order in Tantia came, Tantia said that if merely because in core there was a panel sent to them, if the person himself is per se ineligible, merely because he sends a panel of 5 and says pick up a panel of 4, pick up out of them 2 and I'll choose one of them, how does that counterbalance? And that is why Tantia said we disagree with the reasoning in core and were pleased to refer it to a constitution bench. Now, my lords, it's important for your lordships to see what was the reasoning in core, that one paragraph on counterbalancing vis-a-vis the one paragraph in Perkins. I'm not bothering your lordships with other findings in TRF, Perkins, which are in detail dealing with these issues. If you
in core schedule, 7th schedule, because those provisions make him per se?
Please,
One-
my lords.
One is it, according to you, section clause 64, methodology is a per se methodology.
Yes.
So therefore it falls under what?
No, my lords, then it 12.5 makes it ineligible.
Alpha has to be read, it can't be open it. It has
Entry
to be-
1, my lords, of 7th schedule?
That's what it is.
Yes, sorry, I didn't get.
Yes, yes.
Entry 1, just
According to you, entry 5 is the
entry 1. Arbitrator's relationship with the parties or counsel. The arbitrator is an employee, consultant, advisor, or has any other past or present business relationship with the party.
all that happens.
Please, my lords.
All that is available in 64's application.
In
It's fully satisfied.
in which application?
64 gets fully satisfied and completely gets covered under one.
64 dikhana.
That's the way we have to test, right?
Yes.
Because at the end of the day, the general manager will appoint, and the
Yes.
general manager is hit by the 64.
General manager will appoint, and general manager is hit by the section. The appointing authority is himself ineligible. And that is what Perkins and TRF say, that if the person cannot act as an arbitrator on his own,
Cannot nominate it.
he cannot nominate another arbitrator. That is my respectful submission for your lordship's kind consideration.
Threshold.
And so, to say that what you can't do directly, you can't do it indirectly either. And that is why, my lords, the principle which is also then emphasized is who has an overwhelming say in constitution of an arbitral tribunal. A person, apart from unilateral appointments, the other party not having a say, you're practically vesting it in a party who has been held to be ineligible himself, will now have an overwhelming or unilateral say in the nomination of another person. And that is why Perkins and TRF go on to say that that will undisputably lead to an impression that such a party will be the sole or the major appointing authority, who will in turn have a bearing on the adjudicative process and charting out exclusively the course of the arbitration proceedings. That's the line and philosophy behind these two judgments. Now, my lords, would your lordships be kind enough to have Perkins, paragraph 16, page 1273, 1273, volume 3, paragraph 16 is on there. Paragraph 16, if your lordships were to just hold on. Paragraph 16. Let's have the paragraph.
Yeah.
But in our view, that has to be the logical deduction from TRF. Para 50 of the decision shows that this court was concerned with the issue whether the managing director, after becoming ineligible by operation of law, is he still eligible to nominate an arbitrator? The ineligibility referred to therein was as a result of operation of law, in that a person having an interest in the dispute or in the outcome of the decision thereof must not only be ineligible to act as an arbitrator, but must also not be eligible to appoint anyone else as an arbitrator, and that such person cannot and should not have any role in charting out any course to the dispute resolution by having the power to appoint an arbitrator. The next sentence in the paragraph further shows that cases where both the parties could nominate respective arbitrators of their choice were found to be completely a different situation. The reason is clear, that whatever advantage a party may derive by nominating an arbitrator of its choice would get counterbalanced by equal power with the other party. But in a case where only one party has a right to appoint a sole arbitrator, its choice will always have an element of exclusivity in determining or charting the course of dispute resolution. Naturally, the person who has an interest in the outcome or decision of the dispute must not have the power to appoint a sole arbitrator. Now, this was the reasoning, my lords, on counterbalancing, which was given.
Though one party exclusively appoints an arbitrator, this is counterbalanced by the fact that the other party exclusively appoints their arbitrator.
Yes. So this
was
was
normally
the
the case.
this was the
Normally they adopt
counterbalance.
arbitration. That's
That's between parties.
Yes. So this was the counterbalancing in Perkins that they talked about. Now please see how does core deal with it. Yes. Now please have core paragraph 36. Give me the page. 1306. Same volume. Para 36.
13.
1306. With your lordship's permission. Para 36. Clause 64, subclause 3, subclause B. My Lord the Chief Justice has.
Yes.
Clause 64, subclause 3, subclause B of the GCC deals with appointment of arbitrator, where applicability of section 12, subclause 5 of the Act has not been waived off. In terms of clause 64, 3B of GCC, the arbitral tribunal shall consist of a panel of 3 retired railway officers, retired not below the rank of senior administrative grade officers as arbitrators. For this purpose, Railway will send a panel of at least 4 names of retired railway officers empaneled to work as arbitrators indicating their retirement date to the contractor within 60 days from the date when a written and valid demand for arbitration is received by the general manager. The contractor will be asked to suggest the general manager at least 2 names out of the panel for appointment of contractors nominees within 30 days from the date of dispatch of the request of the railways. The general manager shall appoint at least 1 out of them as the contractor's nominee and will simultaneously appoint the remaining arbitrators on the panel or from outside the panel, duly indicating the presiding officer from amongst the 3 arbitrators. The exercise of appointing the arbitral tribunal shall be completely within 30 days from the receipt of names of contractors' nominees. Thus, the right of the general manager in formation of the arbitral tribunal is counterbalanced by the respondent's power to choose any 2 from out of the 4 names, and the general manager shall appoint at least 1 out of them as the contractor's nominees. My lords, with utmost respect, my submission is this is where the error lies. This is no counterbalancing in the eyes of law. This is no counterbalancing in terms of what TRF and Perkins.
Because the claimant or the respondent in that case has to be confined to the name suggested by the railways.
Yes.
And that's one. And there's no counterbalancing because the railways then appoint 2.
Yes.
May or may not
Yes.
be the panel also.
And out of these 2 also, I give 2, you choose 1 out of them.
One.
And my lords,
And you can't go beyond the panel chosen by the railways.
this was no counterbalancing, and core never held Perkins or disagreed with Perkins or TRF ever. It's not as if core disagreed with TRF or Perkins. It held it to be good law, but thought it was
applied.
Please.
It's applied. You can choose any color as long as it is black. So there's no choice left.
Yeah, that's right.
Also, with a very pertinent question, which during the course of argument, Justice Roy had also put on a panel which is given. Ultimately, a panel which is given. You give me a panel. It can be a broad-based panel. It can be a small panel. It could be anything. And I'll show it from Ein's case. That panel also will change from 5 to 31. I'll show to my lords there. Ultimately, I may choose out of that panel someone I feel is the most acceptable. That still does not mean that the person is my choice. A question that your lordships had put. You give me a panel, now I'll choose what is most acceptable to me out of those 30 names or 40 names or 10 names. But that is still not my choice. So can you curb my choice to appoint an arbitrator? I have to choose, I will choose out of the lot that you've given me. Because I have no other option to do that.
Making a choice is actually truncated. And also, it hits at section 18, which speaks about equal treatment of both parties.
Yes, I'm very grateful.
I mean, that's the core of your argument.
Absolutely, on the panel also. So a panel which is unilaterally curated by one party alone, which is unilaterally curated by one party alone without any say from the other party, with respect, our submission is, does not give us the choice as mandated by law or required by due process of law.
Taking a cue from what fell from Brother Narsimha, the panel that we give, he said, pick any color, but it has to be black. So pick any color, it is deemed to be white.
So, is that enough to say? And even in that judgment, I'll come to my lords and just show where 5 became 31. We don't agree with that position also.
These are Royisms.
Yeah, I have not in my mind.
Mr. Kaul, you have provisions which impose an absolute ineligibility. 7th schedule read with section 12. In cases where the arbitrator is not ineligible within the meaning of the 7th schedule read with section 12, where do we actually source the prohibition in the Act? On the one of the parties providing for a panel, but a panel which is consistent with the 7th schedule.
If that person is himself incapable of ineligible or being appointed as an arbitrator, he cannot also nominate or provide a panel.
You are absolutely. Oh.
How does he provide a panel? Well, how does he provide a panel? If the GM is to provide a panel.
See, Perkins and the other case are cases where the managing director could nominate an arbitrator.
Right, because.
So they said you can't act as an arbitrator because you are the managing director, therefore you cannot nominate an arbitrator.
And similarly, that managing director could not give a panel either. Because that panel is a panel curated by him, my lords. The submission.
You're right. I mean, on grounds of equity, what you say is, it makes sense. But where do you source
so my lords,
the legal norm in this?
My respectful submission going by.
That is flowing out of Perkins.
Please, my lords.
That's an interpretation on the basis of Perkins.
Yes.
Not straight.
Yes. Absolutely. Your lordships are absolutely right.
But where do we locate it in the statute? We want to have a jurisprudential basis in the statute.
Independent of Perkins.
My lords, statute, one is what your lordship said, all parties to be treated equally. If I have to go and be bound by a panel curated by the other side and choose someone from that panel, where is the equality between the two parties? And my lords, it will, with great respect, it leads to serious erosion of confidence as far as the independence and impartiality is concerned.
One more thing which may just reflect on it, which may help your case.
Yes.
Could there be grounds on which a party may object to a panel suggested by the other side, though that panel is consistent with, it does not breach the 7th schedule? In other words, what I'm trying to ask you is, assuming that the other side provides you a panel, none of whom is in breach of the 7th schedule, would there be a legitimate objection on any other ground not falling within the 7th schedule?
Manoj, may I with respect say that I take it that a panel provided is a panel completely eligible, panel completely unaffected by the rigors of 7th schedule, any of the entries therein. It's a panel of impeccable names in every which way.
Your answer is this one only.
Yes.
Which is that under the arbitration law as it stands,
yes,
each party has an unrestricted right to nominate its own arbitrator, untrammeled by the choice of the other party.
Right.
That is, we have to test it on that ground.
Yes, my lords.
Where do you source it in the Act?
My respectful submission for that is that if a person who is ineligible to act as an arbitrator and is ineligible to nominate an arbitrator is also ineligible to give a panel of arbitrators who are unaffected by Schedule 7 entry 1 or any other entry, but he cannot give that panel because the reasoning is the same. What you can't do directly, you can't do indirectly either. The person may nominate someone, but that nominee may not be affected by Schedule 7 at all. The managing director of railways could appoint or nominate a person.
So the objection is about the authority to nominate.
Yes. The authority to nominate. If you, sorry.
What happens is that the contractor, that is his case. He's concerned about his case. But so far as the owner is concerned, take for example NHAI or take for example railways. For them, every day there will be a request for about 10 to 15 or even 20 arbitrations every day. So there is a process by which they will have to continuously keep doing it. So it may become necessary to have some kind of a panel by which they will keep appointing arbitrators. If we give a declaration of the nature that you are saying, that you cannot have a panel at all, inter se in a contract between two parties, or owner of a public sector and a private, if panel is not permissible, then in each case, you will have to individually identify an arbitrators and then appoint it. The process of
May I
such a situation will be very difficult.
may I answer that, my lord? My lord, I'm not for a minute suggesting. I'm not for a minute suggesting there cannot be a panel. I'm not suggesting that. I was just coming to it. I'll just formulate and complete this submission. My only submission is that the panel cannot be curated and unilaterally given by one side. For instance, I'll give an instance.
One question. Yeah, correct. Yeah, I want you to answer that question. Why the difficulty is arising because owner is one, contracts are independent, contractors are independent. If it is a society of contractors, of society of builders, only through the builder society that you come to railways or anyone, then you can have a common panel between the society of builders and railways or NHAI. But that is not possible because these contracts are happening standalone with various.
Well taken.
Then in which case, how does a panel get formed?
Well taken. And I'll just answer that. My lords, just as an example, we now have the India International Arbitration Center Act. We have an institution which is deemed, it's an institution of national importance, presided over by a retired judge of the Supreme Court of India, in this case. What better examples than neutral institutional?
You're saying the solution is institutional arbitration.
Yes.
That's
and that's where the panel will lie. I fully understand what your lordships are saying, different contractors going one to the other. I understand that. Your lordships are right. My submission is twofold. One, the alternative mechanism for appointment of arbitrators from a panel is available in the form of these national institutions. These are acts passed by Parliament calling them institutions of national importance. Secondly, my objection is that the reasoning for a panel that it cannot be curated by an ineligible person is the same what was there for saying that he could not nominate anyone. A person who cannot nominate another person because he is ineligible, that nominated person may be perfectly eligible to act as an arbitrator, but he can't nominate him. Similarly, he cannot give me a panel of 30 or 50 or 5 names.
Would it not be very extreme? I mean, you're right. I mean, yours is an extension argument that if you cannot act as an arbitrator, Mr. Railways, you can't nominate an arbitrator who will act as an arbitrator.
And he may be eligible otherwise.
But would that not be very extreme? Because, would that not be very extreme? Because if the panel which Mr. Railways nominates suffers from any ineligibility, then, because then it's a different thing. I'll tell you why. We are not really in the realm strictly of, this is really an amalgam in many of these cases of public and private law. Say National Highways Authority, Railways, National Hydropower Corporation. They are dealing with contracts worth thousands and thousands of crores. And they are purveying in public money. It's public expenditure and public revenue which is being spent. Now, would they not have a vested interest in ensuring that, look, we are not only concerned with the independence of the arbitrator we nominate, but we want to ensure that there is overall an independent arbitral tribunal. Therefore, the overall tribunal, because this possibly may multi us in huge, we've seen the nature of the awards. Why should we deny them completely the right to ensure that the arbitral panel consists of independent people? If they start nominating cronies, sorry, I use that expression, suppose they nominate a retired employee, certainly there's a problem. Then you point out something to indicate that this panel does not consist of independent names. But suppose they give names of people which are independent. Their only intention then is this. You have a problem with all the names we have suggested? If you don't, what's the difficulty about your choosing one of them?
My lords, may I with respect?
Then your answer can only be one theoretically, that look, I should have an untrammeled right to choose whoever I please in an arbitration.
May I answer that? My lords, what is sauce for the goose is sauce for the gander. If their apprehension that you may just appoint anyone and not from here, we want to protect our interest, I can equally turn around and say that what you're curating as a panel is something in which I have a crisis of confidence. I don't have confidence in them.
Exactly. I agree with you. If you have a crisis of confidence in the panel which they have curated, certainly you have an objection. You have a valid objection. But if you have no crisis of confidence in a panel which they are curating, then why should you have an objection to appointing
But
one of them?
why should
We also see that they should not be then permitted to appoint outside the panel. If they create a panel of 5, or suppose they create a panel of 10, what sauce for the goose is sauce for the gander? You must appoint one among the 10. They must appoint one among the 10, and the 2 arbitrators will then appoint a third party arbitrator.
May I, with respect, say that with utmost humility will not be sauce for the goose and sauce for the gander, because that panel is only curated by them. Either, that's why I said institutional arbitration panels, where an institution curates a panel, and it's open to both the parties. Today, we are talking about a panel, maybe the most
Except that
impeccable panel.
institutional arbitration is still to kick off.
Please, Manoj.
It's still to kick off.
Manoj, we also have the, for instance, I'm giving instances. I'll give instances to your lordships. Manoj, we today have the Delhi Arbitration Center, the Mumbai Arbitration Center, all under the aegis of working under various high courts. Any of these institutions, I'm not today going about questioning every institution where there is a panel. I just gave an instance to your lordships that there's also an act. After all, we have the Hyderabad institution, the Delhi Arbitration Center, the Mumbai Arbitration Center. Any of these institutes working under a credible institution, and can't get more credible than the High Court concerned. If any one of them maintain a panel from where both the parties go and choose their arbitrators, then the whole perception of not only being neutral but perceived to be neutral comes in. Why should I be in any way fettered by the panel you create? What is it that gives you the superior right, which I don't have to curate a panel just because you're the government or a PSU, that you get a superior right to curate a panel? And we should not go to an independent institution which gives us a name of people from which both of us could select. What is it that just being the state gives you the superior right? That's not recognized, my lords, under the law. There's no superior right vested in the state or any institution.
At the end of it, really, your challenge is you are extending the Perkins principle, or you are basically founding it on the basis of 18, equality.
Equality, and my lords, also, for instance, I'll just give an instance. For instance,
there is no
not a direct answer.
Of a gray area in the act.
Not a direct answer. My learned friend points out something which I may just read out. It's not a direct answer to what your lordships asked me. For instance, grounds of challenge in section 12.
Conclude your submissions. We
yes,
are about
my lords,
past 3 o'clock.
In all humility, my lords, I try to cover it as fast as I can.
Make your point.
Yes,
I a lot of questioning for the other side.
Yes, my lord. I just have 4 or 5. I'll just run through, not read any of the judges. Just point out in pointers 4 or 5 judges.
Summarize what you have.
Yes, sir. Can I just point out one thing? Yes. In section 12, my lords, ultimately on grounds of challenge, what you disclose is said likely to give rise to justifiable doubts as to his independence or impartiality. Now, all that I'm saying is that the moment a panel comes from an independent institution, could be anything, those doubts as to impartiality go. But the moment a panel, howsoever impeccable the credentials, is curated by one side to the detriment of the others or to the exclusion of the others, there is bound to be erosion of confidence as far as the independence, impartiality, and fairness of the tribunal and the process is concerned. There is bound to be that, and given the relationship with the state as it occurs on a day-to-day basis in contracts, your lordships gave instances of where so many awards have gone against the state. There are any number of instances where honest private parties have also suffered at the hands of the state and PSUs in such unreasonable demands, claims, and terminations being made from time to time. So many of these companies have been brought to a standstill, bank guarantees encashed overnight.
Actually, Mr. Paul, there is some substance in what you are urging for another reason. Absent a transparent procedure, a lot of people, what they do, a lot of contractors will do is to completely breach the integrity of the process by having the appointing authority appoint people of their choice. That happens through the back door.
Absolutely.
So giving that's the reality, giving the Indian reality. This will not find in the Kluwer articles or the Kluwer blogs written in Netherlands or
Yes,
Switzerland
yes.
or Geneva, wherever.
Absolutely right. Absolutely right.
That is
This
why
is the
we'll have
Indian
to play a
reality.
real-
Yes.
we'll have to-
And that's why I said, my lords, there are problems on both sides, and a party which can influence the outcome of a proceeding can also outcome the curation of a list. So if those are the parties we are looking at, then what is it in fairness that we should look at? Hopefully, two honest parties who come to court, what kind of a panel would they look at? A panel under the aegis of a national institute or a respectable institute like the National Arbitration Center or the Delhi Arbitration Center or the Mumbai Arbitration Center. What could be a better solution than that? Where you completely erase any doubts that could be raised as to the impartiality and fairness of the the panel. Now, my lords, quickly, let me just run through 2 or 3 points on the judgments and then I'm done.
Just formulate them so we take
Yes,
them down.
yes, my lords. My lords, in line with what I'm saying is also the judgment of HRD versus Gale, which is page 1143, volume 3, para 18, your lordships may note, effectively saying that with the 246th Law Commission report and the amendments which have been brought about to the Arbitration Act, they did two things. They narrowed the grounds of challenge under 34 and they introduced 7th schedule and 5th schedule, and section 12 was amended to the Act. The Supreme Court emphasized that in view of these narrow grounds now, we must be even more careful in preserving independence, impartiality, and neutrality of arbitrators, which was said in para 18 of this judgment. That now you have further restricted the grounds of challenge. Thus, even greater care as far as neutrality and impartiality of the arbitrators is concerned. My lords, as far as the judgment in Voestalpine is concerned, it recognizes the principles that it should be broad-based. In fact, that 5 was made 31. The Supreme Court did not interfere, saying that 31 is broad enough. It says it should be broadened. It shouldn't be restricted to retired or serving government employees. You must have lawyers, doctors, chartered accountants, all on the panel. But our objection to Voestalpine will still remain the same on this one limited issue. Of course, it should be broad-based, etc., that the panel cannot be unilaterally curated by one side. That part, my lords.
To that extent, even Voestalpine is also against you.
Yes, my lords. I'm saying so, my lords. I have to bring it to your lords' notice that they said
Because
5 became 30. They said 5 became 31. The other issue, my lord, which has not been argued, which was an issue which arose in another judgment of the Supreme Court, which is not the subject matter here today, but was touched upon by Core, was that under entry 1, could retired employees be part of the panel? That in fact, my lords, the TK Vishwanathan committee report I wanted to point out to your lordships may just note, para 3.88, the report has gone to the Ministry of Law. Para 3.88, page 10690. Para 3.88, page 10690, volume 4, TK Vishwanathan committee report says that there cannot be a, volume 4, 4A, there cannot be a panel unilaterally given from which I am required to pick people. It has to be jointly either prepared by the two sides or institutionally. I'm not bothering for paucity of time, my lords. I'm just making your lordships take notice of the concerned para.
That's the proposed amendment.
That's the proposed amendment that is gone. Now, my lords, your lordships have also in Lombardy, where your lordships said that it was covered by
Project will have been ineligible. At the mo-
Your lodges followed Perkins. And then on the pre-deposit part, because it talked about a percentage being pre-deposited for arbitration to be invoked, your lodges invoked the general principle of legal due process, unconscionable contracts, and something being unconstitutional. So your lodges held that such a contract or a clause which is unconscionable can be struck down, as your lodges have held in many other judgments. So all that I'm saying is that apart from the specific that your lodges were asking for tracing the impartiality to the clause in the Arbitration Act, the fact is wherever your lodges have found a clause to be unconscionable, constitutional, your lodges have dealt with it and struck it down. And Glock also, my lords, your lodges applied Perkins, followed Perkins, and took note of the Law Commission in that as well, my lords. I'm very grateful. If there's something else, my lord, we'll assist in the rejoinder. Very grateful.
Thank you. Now,
My lord, do I have your lordship's liberty?
certainly, Mr.
Yes.
Certainly, Mr. Kaur. Let's come back in 2 minutes. We'll just take a little break for 2 minutes and come back.
Please, Lord. Lord, I'll just address 3 of the points which I wanted to give clarification to.
Can you formulate it?
My Lord, the first point is, my Lord, now the short issue before your Lordship is whether to sustain an arbitration clause as upheld in the court. So when this is coming, let us see the basics of the arbitration clause, my Lord. Basics of an arbitration clause, it is also a part of a contract. It also has all the checks and balances what normal contracts will have. The better thing or better positioned situation of an arbitration clause is because it is giving the responsibility to both the parties to formulate a quasi-judicial authority, which is going to be the first step of the litigation process. So all the other clauses of a contract are mutual obligations and responsibilities of the parties. So my lords will never go into the extent of using public policy against a contractual provision, which is a mutual obligation and commercial things in nature. But this being a clause where, my lord, it has a special status of finalizing or formulating the first step of a judicial mechanism. This is equal to the powers of the High Court in Section 11. So such a power cannot be diluted, altered, or tinkered using the party autonomy. Party autonomy has to stop in front of the public policy test. So the public policy test in Indian Constitution cannot even imagine of having a 1% more power to the other party to formulate a quasi-judicial authority. 100% in all means Constitution ensures and guarantees delivery of justice by a undisturbed or untilted institution. So a clause, when it is crossing that limit of tilting the equality, even by 1% of it, my lord, it becomes unilateral. Not even 1% of the power given to one party more than the other will make that clause unilateral. Then in such a case, public policy has to be applied. Point number 2 is, my lord, with regard to the appointment of the tribunal, replacement of the arbitrators by the court. I beg to disagree with my seniors in this, my lord. Courts do not have the power to appoint the arbitrators in case of a replacement. Because, my lord, an arbitration clause has different aspects of it. It has the language of arbitration, number of arbitrators, seat of arbitration, law applicable to the arbitration, all those things. Particularly intention to arbitrate, that is the first point. When your lordship is going to say that a particular appointing procedure is bad in law, which is not, which makes that arbitration clause unenforceable, then 11.3 comes. 11.3 talks about the situation where an arbitration clause does not have a mechanism to appoint the arbitrator. My lords, kindly see 11.3, my lord. May I read it, my lord?
The submission you're making?
My lords?
What's the point you're making?
Point I am making, my lord, there was a submission from other senior counsels saying that in case the arbitration appointment procedure is held bad in law by the court, can the court appoint replace the arbitrators by themselves, by the court? The court can appoint the arbitrators.
Therefore, that is the procedure is invalid. The court has no power according to you. It's not severable.
It's provided in the law, my lord. 11.3 says that.
Yes.
A person of any nationality may be attend the arbitrator. 2 says, subject to subsection 6, the parties are free to agree on a procedure for appointing the arbitrator or arbitrators. Third, failing any agreement referred to in subsection 2, in the arbitration where 3 arbitrators, each party shall appoint 1 arbitrator, and the 2 appointed arbitrators shall appoint the 3rd arbitrator, who shall act as the presiding arbitrator.
So according to you, the procedure failed. So the procedure is held to be invalid.
Procedure held to be invalid. That particular portion alone vanishes. The rest of the arbitration clause remains. Applicable law will remain. The number of arbitrators will remain. Intention to parties will remain. Seat of arbitration will remain. Only missing link is appointment of the arbitrators. So at that point of time, this 11.3 is the appropriate section to apply.
11.3 will come into play after 6, no?
My Lord,
Under subsection 2 talks about 6.
yes, my Lord. My Lord,
Then the point is something else. Anyway, you complete. You make your subject.
yes, my Lord.
Don't want to interrupt.
My Lord, 11.6 talks about all failures, my Lord.
6. 3 weeks.
So, my Lord, my humble submission is, my Lord, with regard to the appointing authority for the court is given only in 11.6 and section 14. In addition to that, there is no provision in law which is providing the appointing authority. Lord, third one is regarding the tribunal, this panel prepared by the arbitrators, my Lord. My Lord, there are different types of panels prepared by PSUs, my Lord. For example, my Lord, my opposite party, IRCON, has a 36 people panel, which is all engineers, which was given to us, which we rejected, then we came here. The 36 persons, the difference between an arbitral center or some other institution or a neutral institution is the selection of arbitral tribunal is transparent in nature. If I have to apply to FICI as an arbitrator, I got the empanelment. I have to fulfill 10 years of experience, 5 arbitration cases I should have done. I should have an exposure into arbitration publications and all. Fine, I am getting in it. But I cannot get into NHI. It is closed. It is chosen for some people. So that also amounts to a kind of limiting the right of the other party. If it is transparent to everybody, it's fine. Or if it is optional, it is fine. You are selecting yourself and making it mandatory, how it is fine? It cannot be fine. Because you are touching my right, at least by 1%, which is not permissible in law. Because this panel also, they create one big panel, larger panel, and then they will suggest a small panel of 3 or 4 or 5 people. From that, you have to choose one among them. So it further reduces. So that goes away.
So just as an example, in the case of IRCON, can you select anyone from the 36 or they will give you 5 out of the 10?
They will give 5 only, my Lord, but High Court gave me a liberty to select from all. But our contention is, my Lord, as long as the panel is selected at the discretion of some officers in the PSU or government, without a transparent procedure to select. Tomorrow you specify, these are the qualification. This is the month we open for empanelment. You select, fine. It doesn't happen. It happen as per the whatever it is. There are various ways. Or if they want to make a panel, as my Lord said, NHI may have 100 cases. They cannot go and select at that point of time. They have a panel. Then don't compel me to select from there. Let it be an optional panel. If I like, I select. Otherwise, I select from somebody else. That's all my.
Just one query.
Yes, ma'am.
Say railways, you have talked about railways. Now, in railways, there could be so many arbitrations requests.
Yes, ma'am.
Maybe every day there could be 50 or 100 arbitration requests.
Yes, ma'am.
Now, every time they have to look for somebody outside. If they don't have some structure in place, that from this will make choices.
Perfectly all right, my lord. My lord, we don't have any objection to having an arbitration panel by themselves for their use. For us also, it can be given as an option. These are the people, their profile is this. If you want, you can choose. But you don't make us also compelled to choose only from them. Let it be an optional panel, my lord.
No, optional panel is...
Because among the three, my lord.
It's an optional panel. How? We are just trying to understand your logic.
My lord, there are three arbitral...
No, just a minute.
Yes, my lord. Yes.
A panel is there. Say railways, let's take railways. Panel is there.
Yes, ma'am.
And you are saying that if they ask us to choose from there, it is all right, but they should not give those choice of 4 or 5. Is that what you are saying?
Even choosing, my lord, your my rights are reduced, my lord, because
right.
it is
Then
not a
how are you
transparent
saying-
panel.
Then how are you saying that panel is all right? He says.
My lord, panel. Because, my lord, the beauty of arbitration. Yes, my lord, I am not.
Railway can say that I select A out of my panel of 50.
Yes.
And the contractor says he is not of this 50, but he is my nominee.
Yes.
And between the two, they will have the...
Perfectly all right.
And if
That
the
is
contractor, according to you, wants to select one from the railway panel, that's fine. That's his choice.
fine, my lord.
Give him a choice. According.
My lords, the beauty of arbitration is, my lord, if a party is selecting an engineer in an engineering contract, if contractor is selecting a judge or some legal person, that will be a very nice combination. No requirement for an expert witness. If there are two judges, there is a one engineer. So these all can happen when the liberty is given to us. When liberty is curtailed, all these go. Everybody sits, all three retired engineers. My lord, so last submission, my lord.
Yes.
Just one word, my lord. My lord, section 12, schedule 5 and 7, in my opinion, should be kept away while deciding this matter, my lord. This is a matter which is going to decide a system which is going to test the arbitration clause and its validity. My lord, that is a post-appointment system. The post-appointment system prescribes 19 items in the Schedule 9 and 34 items in Schedule 5. They are only an opportunity for the parties to know about their personal connections. So that is a different issue that should not be kept in mind while deciding this. Here, my lords are going to decide the validity of a clause or a system which will ensure neutral arbitration. Lord. Much obliged.
Thank you so much, Mr. Ravi Shankar. Mr. Rohan Talwar.
My lords, I'm going to address my lords firstly on a proposition which has not been discussed, which is the skewed incentive which arises in unilateral appointment procedures. My lords, on two stakeholders. One is the appointing authority.
So you're saying skewed incentive.
My lords, in cases where there are unilaterally appointed panels or unilaterally proposed panels. My lords, firstly, qua the appointing authority, anyone who is going to be rendering a verdict in their favor, there is a perverse incentive in economics which is called to reappoint that person in the panel. And my lords, it's a known thing that panels are reviewed periodically and thereafter curated. My lords, the second skewed incentive is of the arbitrator in this case, who, my lords, has an incentive to remain on this panel. So, my lords, what would happen is that
What is the first skewed incentive?
my lords, of the appointing authority, that if I'm an arbitrator and I give a judgment in favor, let's say, of the appointing
Be
authority,
reappointed.
I'll be reappointed. And
And there is no provision in the Act which bars reappointment in more than one arbitration.
absolutely, my lords. My lords, there may be
Sorry?
cooling.
Three times.
Beyond three.
And
Schedule 5.
my lords, here, so
Schedule 5 item.
Schedule 5 is it? I know.
Schedule 5.
Previous services. Item 20.
22. Yes, ma'am. 20.
Data has within the past 3 years served as
22, ma'am.
been appointed as an arbitrator on 2 or more occasions by one of the parties or an affiliate of one of the parties.
my lords, however, this is on the point of impartiality at the stage where I'm questioning the appointment. I'm saying that in a year,
So in 3 years, you can't accept more than 2 arbitrations from one party.
my lords, however, if
So
I'm to be
Therefore, it's clear in a case where you come across a situation where a person in the panel has already been appointed twice, you would say that you can't appoint him at all.
my lords, firstly, these aren't
That's
disclosed.
different from what's being argued.
But one of them was saying after.
Repeated.
My lords, I will only pick a
Good
person,
point.
even after the scope of 3 years, who has decided in my favor. And within those 3 years, I can repeatedly appoint up to twice for someone who's decided in my favor. This is qua the appointing authority, let's call them railways. For the arbitrator also, my lords, the perverse incentive is to remain on this panel. And my lords, I may be on several panels. I may duplicate my appointment, and therefore this perverse incentive, in fact, is recognized in a judgment, my lords. It's by the name of Hooters of America versus Phillips. It's at page 3585 of volume 3, my lords.
Hooters was actually referred to in that judgment which was cited by Mr.
My lords, Mr. Banerjee also referred to it. There's just a sentence there which I want to refer to, my lords. So here also there was a panel.
So what they have held, they said that such person is ineligible to be appointed.
My lords. And there's a very interesting sentence, my lords, just following from what my lord said.
Read.
My lords, I'm at page 3589, relevant. The appointment procedure is the employee and Hooters each select an arbitrator, and two arbitrators in turn select a third. Similar to core, similar to my case as well. My lords, the bottom of that paragraph, fourth line. Further, nothing in the rules restricts Hooters from punishing arbitrators who rule against the company by removing them from the list. Given the unrestricted control that one party, Hooters, has over the panel, the selection of an impartial decision maker would be a surprising result. My lords, this is one incentive I wanted to.
Interesting. So within a period of 3 years also, you appoint an arbitrator on a second occasion.
Absolutely.
And once, even after the period of 3 years, the bar of 3 years has expired, you will have an eye on who held in your favor in a previous arbitration. That's your point.
3 years may be a cooling off period, but after that, as my lords are saying, I'm aware who is decided in my favor.
So therefore, in the new proposed amendment, exactly this is what it is. The proposed amendment says that we will now have, instead of a prohibition, a cooling off period.
Apologies, my lord, I couldn't.
There's a cooling off period suggested by
my
the new
lords.
panel.
And my lord, the second point I want to raise is regarding the legislative infraction. What is exactly prohibited under this act? My lords, I want to read a sentence at the cost of repetition in TRF and one sentence in Perkins. If my lords may have page 1033 of TRF.
What do you want? Was the submission?
My lords, the submission is that there is a implicit legislative bar arising out of the fact that an individual who has an interest in the outcome of a dispute cannot be made the appointing authority.
That Mr. Paul argued.
My lords, just a sentence to show where is this coming from legislatively. What is the statutory bar here, which these two decisions in my respectful submissions have addressed already. My lords, at para 57, 1032 bottom, in such a context, the fulcrum of the controversy would be, can an ineligible arbitrator like the MD nominate an arbitrator who may be otherwise eligible and a respectable person? As stated earlier, we are neither concerned with objectivity nor individual respectability. We are only concerned with the authority or the power of the managing director. By our analysis, we are obligated to arrive at the conclusion that once the arbitrator has become ineligible by operation of law, he cannot nominate another as an arbitrator. And I'll end at the next sentence. The arbitrator becomes ineligible as per prescription contained in 12.5. Now, my lords, this is interpreted in Perkins and without apologies. My lords, this next sentence from Perkins is at 1274, my lords. I'm reading paragraph 16, where they interpret what is this. Well, I'll just read that sentence. The ineligibility referred to therein was as a result of operation of law, in that a person having an interest in the dispute or in the outcome of a decision thereof must not only be ineligible to act as an arbitrator, but must also be eligible to appoint anyone else as an arbitrator. My lords, at the foot of this paragraph, that has to be taken as the essence of the amendments brought by the Arbitration and Conciliation Amendment Act 2015. Independence, my lord said, is a complete virtue. It can't be negated at margins. So, my lords, if independence has to be seen as an absolute virtue, this amendment introduced independence and impartiality. What my lords have said in Perkins is that the essence of this amendment is that an interested party cannot adjudicate. If an interested party cannot adjudicate because they have an interest in the outcome, they cannot nominate. Now, whether I nominate 1, 2, or 100 is immaterial.
Thank you. Thank you, Mr.
My lords. Obliged, my lords.
Now,
It
Mr.
will-
Anil, yes.
Keep it extremely brief, my lords. My lords, I locate impermissibility under 3 heads. First, Section 18 of the Arbitration and Conciliation Act. Second, Section 23 of the Contract Act. And third, where there's a state party involved under Article 14. Insofar as Section 18 is concerned, my lords, my note contains various references, a lot of which my learned senior Mr. Banerjee has already referred to. But in substance, my lords, what Section 18 proscribes is the inequality in the process, including the appointment process. What it requires is absolute equality. And if absolute equality is not guaranteed at the stage of appointment, absolute equality is impossible during the process. Now, this, my lords, this equality is completely independent of independence and impartiality. Independence and impartiality is a separate paradigm covered by Section 12(5) and the 2 schedules. Equality, and when I refer to equality, I'm referring to the lack of mutuality in the appointment process. Any unfair advantage that any party has at the stage of appointment will result in a violation of Section 18. Let me give an example. There could be so many scenarios where the panel is perfectly eligible, but the party nominating the panel may fill the panel with arbitrators who have already decided a similar issue in their favor in the past. So, in such a scenario, my lords, there is no 5th schedule or 7th schedule violation, but there will still be a violation of right under Section 18, because why should one party have the right to fill the panel with people of their choice?
In fact, you're right. I asked a question in the morning. Are there any apprehensions or objections independent of the 7th schedule? And this is what you are saying, that you appoint.
And I can give a real life example. We did multiple arbitrations in relation to metro rail construction. There was one exclusion clause which was the subject matter of litigation in most of these arbitrations. Now, the first set, we had a completely independent panel. The second set of panels that were given to us comprised of only those who had interpreted that clause in favor of the Metro Rail Corporation. Now, today, if the Metro Rail Corporation has this unilateral power, it's independent of 5th schedule, independent of 7th schedule, but is it not a violation of equality under Section 18, I ask myself. This is the first point. Second, my lords, to answer a query that fell from your lordships is that this Section 18 is located under Chapter 5, which deals with conduct of the arbitration.
But does that not go to the panel as opposed to, the power?
Sorry, my lords?
Does your argument not therefore impeach the panel as opposed to the power to...
My lords, the panel is perfectly eligible because there is no question of subject matter. There is no entry relating to subject matter bias in 5th schedule and 7th schedule.
Well, really speaking, as no, it doesn't encroach, does not breach any provision of the statute.
It doesn't breach any provision of the statute, but the panel comprises of only those arbitrators who have decided the very same issue in favor of the party appointing the panel. That's the reason why, my lords, even though party autonomy is important, party autonomy has to be balanced with... Sorry, my lord.
As against each of the arbitrator who had decided similar cases against them.
They have only decided one such case, but that's enough. They have not decided more than two, so therefore fifth schedule will not come in. So today there is no grievance against the individual arbitrators, but it is that party that has filled the panel with persons who have already decided the issue in the past. A party should not be permitted to weaponize the appointment process.
Party autonomy cannot be for one of the party, but party autonomy has to be mutual for both the parties.
And I go down, my lords, and party autonomy has its limits. If there is a mandatory provision of law, such as Section 18, party autonomy would give in to such a mandatory provision, because having a blemishless process is an equally, if not more important consideration. Today, your lordships has laid down the law in relation to minimum judicial interference. Why? Because it presumes that the regime is blemishless today, because of the fifth schedule, because of the seventh schedule.
Blemish. In TRF, they mentioned that we are not concerned about respectability, right? So, persons who have decided on a particular aspect in favor of the organization may be more respectable.
I go back to what my learned friend argued on the incentives for appointment. Yes, my lords. Then, my lords, before I conclude, my lords, there is one passage, I don't think I may have the time, but I'll only provide the reference to the drafting history. Some portions of the drafting history my learned senior read out, but at page 9823, volume 4, tab 135.
But you know, your point that, look, suppose they constitute a panel, and that panel only consists of people who have arbitrated in the past and say decided that issue, construction of a specific notice provision for termination favorably to that particular employer. Can you not raise a ground of challenge under 12A?
No, not because it's not any of the grounds contained under Schedule 5 or 7.
No, but 12A doesn't confine you to only the 5th or the 7th schedule. The 7th schedule. 12 says, such as the existence, either direct or indirect, of any past or present relationship with, or interest in any of the parties, or in relation to the subject matter in the disputes, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to his independence or impartiality. So suppose a railways or any PSU appoints an arbitrator who has decided that very issue. All the arbitrators in the panel are people who have decided in their favor.
May I, two aspects.
This not be a ground.
First, I will never know as a contractor, because what needs to be disclosed would only be what is set out in the 5th schedule. So if this is not covered on the 5th schedule, so I will never know whether they have decided in the past or not. Point number one. Point number two, let us assume that they have decided the same issue, not in relation to the same Metro Rail Corporation, but in relation to another public sector undertaking. Your Lordship sees exclusion clauses in so many cases, so many government contracts.
You have decided the same interpretation.
Same interpretation. So why should one party have the benefit of picking?
There is an asymmetry of information according to you, because the contractor will not know everything about that arbitrator.
I bow down, my lord.
Or each of the arbitrators.
And my lords,
identifying the background, you'll have to engage a detective agency to find out the background of the arbitrators.
My learned senior also mentions that HRD Gale.
Same was rejected.
Where?
HRD versus Gale, the arbitrator had given a similar award earlier.
That was rejected.
Yes. So, my lord, the problem here is the process and not the individual arbitrator. That's the real problem.
My lords, then, my lords, on the issue of whether, even though it is located in Chapter 5, whether Section 18 will apply to the arbitral appointments, my lords, there is one reference I would like to provide your lordships. at page 9823, volume 4, tab 135, which is part of the drafting history of the ancestral model law. My learned senior read out certain portions. This portion also deals with it and specifically says that it will apply to the agreements between parties in relation to the procedure for the arbitration. And even when your lordship sees the scheme, even though it says conduct of arbitration, 18, 19 and 20 are prior to the notice of arbitration. 19.2 gives parties to agree upon the liberty in relation to the procedure. 21 gives parties a liberty to agree upon the place of arbitration. Therefore, when you look at the scheme, even though Chapter 5 deals with conduct, it begins with the agreement between parties on various aspects before going into 21, which is the commencement of the arbitration, and thereafter the procedures like pleadings, etc. in the arbitration. Therefore, my lord, the reading of the scheme, along with the drafting history in my respectful submission, would in my respectful submission make it clear that section 18 applies to the appointment process as well. This passage, my lords, is very, very clear. The passage that I just mentioned, I've referred to it in my note, my lords. I don't want to read it out because of the paucity of time. Finally, my lord, just one before, if your lordships is to accept this contention that section 18 applies, there are various issues that will arise. What happens to arbitrations that have been concluded? What happens to arbitrations where the challenge is pending? Because section 18 was unamended. It will apply even in the pre-2015 era. Therefore, your lordships may consider using the power under Article 142 to restrict the applicability in a post-2015 scenario where a challenge has been raised and is pending before a court today. Because if it is going to apply across the board, it will... Second consequence, what happens if the offending portion alone is severed? Can the doctrine of severability and blue pencil rule be adopted, and can the court then go ahead and appoint an independent arbitrator? In this regard, my lords, if one party has provided consent on the basis that it has a right to unilaterally appoint or appoint a panel, that goes to the root of the consent to arbitrate. Therefore, in my respectful submission, the doctrine of severability and blue pencil rule cannot be read in because it vitiates consent in the first place. So if your lordship is to accept the section 18 argument, the arbitration clause itself goes, point number 2. Point number 3, who can raise it? Can today the party that has nominated the panel and thereafter lost in the arbitration go and challenge it saying section 18 has been violated? In my respectful submission, that the answer would be no, because in such a scenario, the right under section 18 itself would not kick in. Section 18 is a right that accrues for the benefit of the party that is discriminated against. Deeply obliged, my lord. There are a lot of foreign judgments and articles that I've referred to in my note. I don't want to go into all of them. Deeply obliged.
Lord, I will take 4 minutes exactly since, Lord, I appear for Shaparji Palanji, Lord, which is a contractor. We had filed an intervention, Lord, and mentioned yesterday. Lord, I've mailed my note to the court master, and very briefly, I've formulated my points over the lunchtime. I just get copies. Lord, we are carrying the hard copies also, Lord. Lord, very quickly, my points.
The submission?
Lord, my submission is obviously to say that 4 points, Lord, I'm making. Section 7, which talks about arbitration agreement, does not include an agreement on who will appoint. It's only limited to intent to arbitrate. And I'll read section 7. Means an agreement by the parties to submit to arbitration. So once that test is satisfied, the second conditions which parties often put, that unless I appoint, only then I will go to arbitration. Or it can be only from my panel. Then only, that was a question that had come from Lordship in the beginning. What if it is a conditional arbitration clause? But the requirement of section 7 is limited to intent to arbitrate. Right to appoint or unilateral right to appoint or limited to panel of appointment has to be divorced from it. They cannot go together. Once the test of intent to arbitrate is satisfied, then law kicks in.
Yeah.
That's my first point, Lord. I put it in my note, submission number 1. And Lord, intent to arbitrate has been recognized in the Cox and King's judgment, which on the group of companies doctrine. So that's my first point. Intent to arbitrate is the first step. As per 7, arbitration agreement has been defined to means an agreement so and so. It is not predicated as to who will have the right to appoint. Thus, existence of an arbitration agreement gets satisfied as soon as the requirement of 7 is met. Now, my second point is there are 3 aspects of constitution of an arbitral tribunal: intent to arbitrate, commencement, and procedure. These are the 3 aspects before a tribunal is in place. Now, 11(2) uses the word parties are free to agree on a procedure. Lord, actually the main mischief is here. How much stretching do we give to the word procedure? Does it mean procedure in case parties fail to agree? Or would Lordship consider procedure to mean even determining who will appoint among the 2 parties? Procedure will only mean, Lord, methodology. The real problem is procedure, my lord. If Lordship gives interpretation to the word procedure in 11(2), the entire problem gets solved. That's the Gordian knot. Because that is where the agreement is referred to, which gets used. That, oh, I have a right to agree on the procedure for appointment of an arbitrator. That means I can decide who will be appointed as an arbitrator. My lord, my submission here would be, keeping in mind the mischief rule, Hayden's rule, purposive interpretation, the word procedure will have to be limited to mean in case parties fail to agree, then what is the procedure? Lord, that is what is the fallback also in 11(5), Lord. Then 11(8), which Mr. Banerjee had referred, my lord, has the words independence. And it also uses the word other considerations. Lord, Lordship had put a question, what is their other? Those other considerations would kick in because it's a very wide term. Lord, on section 18, my lord, I have referred to the judgment of PAM development, which had made section 18 applicable to even post-arbitration. And my lord, on panel, my lord, I have just 2 points to make. What cannot be done directly should not be done indirectly. If Lordship is permitting one party to appoint an arbitrator, then panel will be justified. But if one party can't appoint a sole arbitrator or the presiding arbitrator, then even panel cannot be justified. Lord, if 3 people cannot be appointed by 1 person.
So tomorrow we'll start with the arguments of the Solicitor General.
Lord, one request, Lord, my colleague says the intervention may be formally allowed, Lord.
Yes, we allow it.
I'm grateful.